On the night of July 6, 1999, James Earl Livingston had a psychotic episode. Suffering from delusions, he believed his brother-in-law was chasing and trying to kill him. Livingston, a 31-year-old man with schizophrenia from Tarrant County, Texas, ran to the police for protection. In about 8 hours, half of that time spent in a restraint chair, Livingston was dead. The Tarrant County Medical Examiner's Office ruled in August 1999, that Livingston's was a natural death caused by bronchial pneumonia. But that's not the whole truth, says Richard Haskell, a lawyer who is representing Livingston's mother, Maxine Jackson, in a suit against the Tarrant County Sheriff's Department. He says Livingston's last stint in the chair killed him. So far as we know, he was pepper sprayed in the face and then placed in a restraint chair, says Haskell. Livingston was not allowed to wash the pepper spray out of his eyes or off his face in apparent violation of Tarrant County Sheriff's Department procedures, says Haskell. He was not decontaminated, and he was left alone in a room. Within 20 minutes he was dead. Pepper spray inflames the mucous membranes, causing closing of the eyes, coughing, gagging, shortness of breath, and an acute burning sensation on the skin and inside the nose and mouth, said Amnesty International in a 1998 report on human rights abuses in the United States. There is considerable concern about its health risks. Deputy Mark Lane Smith was the first person to perform artificial respiration on Livingston in an unsuccessful attempt to revive him. When another deputy took over, wrote Smith in a detention bureau report, I then removed myself from the area and walked into the Sally Port, where I threw up from inhaling pepper gas residue from inmate Livingston. It's hard to imagine the terror someone feels who is buckled into a restraint chair after being pepper sprayed, says Haskell. You wouldn't do that to a dog. The chair that held James Earl Livingston for more than 4 hours, on and off, on the night of July 6, 1999, is manufactured by KLK Incorporated, of Phoenix, Arizona. The KLK chair sells for $2,290, plus a $190 crating charge. This violent person restraint chair has been in use by the 6th largest sheriff's office jail system in the nation for 4 years, with a 90% reduction in injuries compared to the previous 4 years, brags the company advertising. Special sizes and colors available upon request. I telephone KLK for their take. Teresa Dominguez, production coordinator with the company, tells me the chair is sold mainly to prisons and mental hospitals but says she can give me no other information. On her advice, I submit a fax of questions for the company's officers. After more than a week without a response, I call back. They basically said they can't answer the questions, says Dominguez. The owner saw the fax and said, no, we won't answer these. The company also declined to answer questions about the death of James Earl Livingston. But Dominguez says the chair isn't to blame. How they use the chair, I imagine, would be the question, she says. Another manufacturer is more forthcoming. Dan Corcoran is president of EDEC International Incorporated, of Beaverton, Oregon, which manufactures the popular prostrate violent prisoner chair. Corcoran says his chair is humane and was designed to be so. You know, when you take a little bird and it's lost and confused, and at first its heart is beating, he asks. But if you fully cup that bird in your hands and immobilize it, the bird, he says, calms down. So, too, says Corcoran, with human beings. The chair makes a real nice sit for them. What about allegations that the restraint chair has been linked to several deaths and that it is easily misused? The people who want to do good start gainsaying it, calling it a medieval instrument of torture, says Corcoran, who has no patience with this stance. It's a way of getting attention. When I ask Corcoran for a press packet, he tells me he doesn't have one because every lawyer who doesn't have a job will want to get hold of the press packet and take his words out of context. He will, however, tell me the chairs cost $900. If you get the accessories, $1,300. He will also tell me who his customers are, mostly county jails, but also state prison systems, the U.S. Bureau of Prisons, the U.S. Immigration and Naturalization Service, the U.S. Marshals Service, and the Forest Service. Park Service, too, he says. Every state, every province has it. Corcoran also exports his restraint chairs, but only to the countries that really believe in human rights, he says. A lot of countries are looking into this right now. We're kind of ticklish about selling these to third world countries that don't have human rights because there really is a possibility that they might be abused. Among those countries that have gotten Corcoran's okay and now have EDEC restraint chairs is the United Arab Emirates. According to Amnesty International reports on the United Arab Emirates, cruel, inhuman, and degrading punishments, including flogging and amputation, were repeatedly imposed in 1999. In 1998, torture and ill treatment were reported and the use of cruel judicial punishments increased significantly. In 1997, said the human rights group, torture and ill treatment of detainees in police custody continued. Corcoran says he has sold thousands of the chairs. But as to the exact number, we don't tell anybody that, in court or otherwise. A flyer for the chair recommends its use for interrogating prisoners and for detaining people in holding tanks in mass entertainment facilities. It appears to be used primarily in the intake and booking sections of local jails. Many of those who end up in the chair have not been convicted of a crime and have landed in jail for minor offenses, such as public drunkenness. The mere presence of the restraint chair is asking for abuse, says Charles T. Magarahan, an Atlanta attorney. On June 5, 1997, Magarahan's client, Christopher Stone, was beaten, strapped into a restraint chair, and then beaten again after he was arrested for drunk driving and brought to the Cherokee County Jail. He had not been uncooperative, says Magarahan. He kept saying, "I'm with you guys." They put him in the chair, but they didn't push it like you'd push a chair. They dragged him by his head, with him screaming in pain. When plaintiff was in the holding cell, totally restrained, defendant were returned to the outside of the cell and sprayed pepper spray underneath the door, says the legal complaint that Stone filed against Ware, Cherokee County, and 2 other jail employees. No one bothered to decontaminate Stone. Then, once the cloud of gas subsided, says the complaint, Deputy Ware returned and sprayed under the door again. In a separate suit, Ware was also prosecuted for using excessive force against Stone. On November 4, 1999, he pleaded guilty. He was sentenced to 1-year probation and fined $1,000. He has also been dismissed from his position. In February 1999, the Sacramento Sheriff's Department settled a class action lawsuit alleging that deputies were torturing people, many of them women and minorities, with a restraint chair. The cost of the settlement was $755,000, the largest for alleged officer misconduct in the department's history. The lawyers who brought that suit are demanding that the restraint chair be banned. The Sacramento case alleged numerous and repeated forms of torture, including mock executions, where guards strapped prisoners into a prostrate chair and told them they were about to be electrocuted. Catherine Martin, a 106-pound woman with a heart condition, claimed she spent 8.5 hours in the chair after she was wrongly accused of touching a guard. She alleged that the straps had been pulled so tight that they had sliced skin from her back and shoulders and cut off circulation to her extremities, causing permanent nerve damage. She also claimed that she was given no liquids and that she was taunted and mocked. She was denied her requests to use the bathroom and ended up urinating on herself. Martin had originally been brought into the jail on suspicion of public drunkenness. This charge was later dismissed. Videotapes of the Sacramento jail's restraining methods played an important role in the case. In one tape, Ronald Motz calls through the window of his cell, asking for his lawyer. "Motz, this is the last time we're going to tell you, sit down," says a police officer, "your attorney's not here, and the phone doesn't work." Motz continues to call out. After a break in the tape, Guards wrap a spit mask around his face and pull him into a chair. "I just want to call my attorney," says Motz. "You don't get to call an attorney," says the officer. "Why?" asks Motz. The officer tells him that he can't make the call because he was drunk in public. A few seconds later, the guard says, "You were going to be released in about 5 hours, now you're not." "What did I do wrong?" "Ask for my attorney," asks Motz. "You weren't following directions," says the guard. The videotapes also show a woman named Gina DiMaggio being put into the chair naked. She yells at the guards who are kneeling on her back and spits blood on the floor, apparently because her mouth has been injured. The guards respond by wrapping her face in a towel. They keep the towel on her face and at one point appear to hold it against her mouth as they force her into the chair, although she repeatedly says that she has a thyroid problem and that she can't breathe. Kimberly Bird was reportedly taken to the hospital after she passed out in the chair where she had been hooded and tightly bound, according to a letter Amnesty International wrote to the Sacramento County Sheriff's Department in March 1999. In the videotape of her restraint, she is obviously terrified. "I'm going to die. Please don't let me die," she says over and over again. The Sacramento case, Giovanna D. Lobdell vs. County of Sacramento et al., listed EDEC International Incorporated as a defendant. EDEC's Corcoran gave a deposition on June 8, 1998, to attorney Stuart Katz. Many of Katz's questions referred to a manufacturer's warning sheet Corcoran distributes to his clients. The purpose of the prostrate chair is to provide law enforcement and correctional officers with the safest, most humane, and least psychologically traumatizing system for restraining violent, out-of-control prisoners, reads the statement of purpose included on the warning. The chair is not meant to be an instrument of punishment and should not be used as such. The following are selections from Corcoran's deposition. Q. What testing did you do? A. I put various friends in there. I yanked on that as hard as I could, and I'm physically a PT. I could cause no pain to them whatsoever. Q. Now, does your manufacturer's warning make any reference to minimum age constraints for persons to be restrained in the restraint chair? A. It does not. Q. And does it refer to any maximum age constraints for people to be placed in the restraint chair? A. No, it does not. Q. Does it convey any warning as to whether individuals with specific health problems should not be placed in the restraint chair? A. No. Q. Well, are there any physical conditions that you believe should lead to a person not being restrained in the chair? A. No arms, no legs. Q. All right. So you don't believe the chair should properly be used on amputees or people born without fully developed limbs? A. The chair wouldn't be functional unless they had appendages. Q. Is it a fair statement that it's your opinion that the chair is less psychologically traumatizing than the alternatives you mentioned? A. Yes. Q. Is that opinion based upon any medical or psychological expert work in the field? A. No. Q. Now, it is an especially useful tool for restraining drug or alcohol-affected prisoners. Period. My question, sir, what is your evidence for believing that it is especially useful for people who are on drugs? A. Because medical restraints at that point are very dangerous. Q. And what is the basis for saying the medical restraint at that point is dangerous? A. Because they have not diagnosed what is in their bloodstream already, and whatever is put in there is compounded. Q. Was there any scientific literature you relied on to come to this conclusion? A. That's common sense. Q. Did you do any testing on people who were under the influence of drugs or narcotics? A. No. Q. Did you do any testing for people who are under the influence or feeling the effects of alcohol? A. No. Q. All right. Now, the last statement under your statement of purpose, the chair is not meant to be an instrument of punishment and should not be used as such. Why did you include that sentence? A. Because Mexico asked to purchase 200 of them, and I wouldn't sell them to Mexico. Q. And why wouldn't you sell them to Mexico? A. As any instrument, car, toilet plunger, they can all be abused. There was too high a potential because we have a much higher standard in this country than other countries do. That's why the chair does work here and people will buy it. Q. People go to the bathroom while they are seated in the chair. Are there provisions in the design of the chair to evacuate those excretions? A. Yes. Q. What are those? A. The thing is cupped. Bloodborne pathogens and bodily fluids are contained in the person's clothes. I felt that was a better choice than let the pathogens go into the cell and infect other people. Q. Have you looked at any of the literature regarding how long a person can safely be restrained in a prostrate chair? A. There is no literature that I know of. Q. Have you done any studies, research, as to the maximum amount of time an individual can be restrained in your restraining chair without causing a physical injury? A. No. Q. Now, if you thought the chair wasn't punishing, why wouldn't you sell those chairs to Mexico? A. Because I have seen enough movies, and I may be stereotyping, but there could be interrogations. I didn't want that to happen. Q. Is it a correct statement that you marketed the prostrate restraining chair for use which includes interrogating prisoners? A. Yes. Efforts are now underway to restrict or ban use of the chair. In August 1999, a Knox County, Tennessee, judge ruled that the confession of robbery suspect E.B. Boyd Collier was involuntary and illegal because it came while he was confined in a restraining chair during his 5-hour interrogation. While such a chair may be useful, it easily crosses the line as a coercive force, wrote criminal court judge Mary Beth Leibowitz. A March 1996 Department of Justice investigation of the Maricopa County jails in Arizona found that the sheriff's department used stun guns on prisoners while they were confined in restraint chairs, including one case where jail staff used a stun gun against a prisoner's testicles. According to Amnesty International, one prisoner, Richard Post, was forced into a restraint chair in a manner that is reported to have caused compression of his spine and nerve damage to his spinal cord and neck, resulting in significant loss of upper body mobility. On August 19, 1999, Maricopa County agreed to pay Post $800,000 to settle his claims that jail guards had used excessive force against him. In 1997, jail officials told Amnesty International that the jail system owned 16 chairs and that it had used them about 600 times in the past 6 months. The Maricopa County jails have since altered their restraint policy and say that they no longer use the chairs for punishment. A Department of Justice lawsuit against the jail system was dropped in June 1998. Alleged misuse of the restraint chair led the U.S. Department of Justice to file a 1996 lawsuit against the Iberia Parish Jail in Louisiana, claiming that the jail deputies, as a matter of course, subjected prisoners to cruel and unusual punishment and physical and mental torture by confining them to restraint chairs for hours and forcing them to sit in their own excrement. One prisoner was allegedly held in the chair for 8 days, another for 43 hours. In a pretrial settlement, the jail authorities agreed to stop using the restraint chair. In early January of 2000, a group of Erie County, Pennsylvania, prisoners asked a federal judge to ban use of the chair. The suit against the prison alleged that prisoners had been held for 2 to 8 hours in the chair for such behaviors as making insolent remarks, cursing, and throwing towels at one another. In Ventura County, California, a class action lawsuit led a federal judge to issue a preliminary injunction banning the chair on November 15, 1999. That order is being appealed. The lawsuit alleged that during one 18-month period, 377 people had been strapped into the chair at the Ventura County Jail and that one prisoner had been left in the chair for 32 hours. Data shows that the Sheriff's Department's misuse of that chair flows from a practice of restraining nonviolent arrestees for extended periods of time in violation of the arrestee's 14th Amendment rights, wrote U.S. District Judge Lourdes Baird in her 50-page decision. The policy allows deputies to require restrained arrestees to either urinate or defecate on themselves and be forced to sit in their own feces or hold it. On December 13, 1999, Amnesty International issued a statement calling for an inquiry into police actions at the WDO protests in Seattle. Among the allegations that troubled Amnesty were several incidents involving restrained chairs at the King County Jail. People were allegedly strapped into four-point chairs as punishment for nonviolent resistance or asking for their lawyers, says the group's press release. In one case, a man was stripped naked before being strapped into the chair. Martin Myjal, a building contractor in Portland, Oregon, participated in the WDO protests. He was arrested with other Direct Action Network protesters and charged with failure to disperse. After 10 hours of waiting in several jails, and hearing that a lawyer was on her way, the group decided to resist the deputies' attempts to transfer them to individual cells. According to Myjal, they linked arms. Myjal says the deputies responded by bringing in several restrained chairs. They then began to separate the protesters. I was holding myself in a ball with my arms locked under my legs, writes Myjal in his complaint to the ACLU of Washington. As they carried me, I cried out "lawyer" 3 times because I was very scared and I thought they might be close by. Myjal says he did not resist as the guards placed him in the restrained chair. Then, as I remained entirely incapacitated in the wheelchair, and totally by surprise, a male guard put pepper foam directly into my eyes. It was very, very painful. Instinctually, to get the foam out of my eyes, I wiped my forehead against the nearest thing, which was a guard's leg, who was standing to the side of me, and I heard him yelp when the chemical burned through his pants. Myjal's action angered the guard. Then he took a cloth and put it over my face, he writes in his ACLU complaint. He put his hand on the cloth and with his finger found my left eye socket and rubbed the poison in my eye, forcing my eyelid up. Then he lifted the cloth and put another pad of thick cloth over my mouth and gagged me. I couldn't breathe at all, because of the pain and the fear. I was in immense agony. We would dispute that account, says Jim Harms, Public Information Officer for the King County Department of Adult and Juvenile Detention. He claims that the deputies were simply following procedures and that the activists shouldn't have expected to see their lawyer so quickly upon arriving at the jail. He also says that the officers used a standard use of force progression on Myjal, that he struggled with the guards and refused to be restrained, and that he was pepper sprayed just so the deputies could get him into the chair. As for being pepper sprayed while restrained, hooded, poked in the eye, and gagged, there is nothing in the report or the follow-up review to show that actually happened, says Harms. If you've ever seen the film Brazil, it's like a scene from the torture chamber, says Robert Smith of San Francisco. Smith, an activist with Art and Revolution in San Francisco, was arrested along with Myjal and backs up his claims. He's being held down, he's got a bag over his face, there's people in riot gear all around him. This is after being pepper sprayed. I'd never seen human beings doing something like that to other human beings. This article was originally published in The Progressive, 2000. Cowboys and Prisoners. Willie Wisely. 1. It was trumpeted as the pinnacle of high-tech prison architecture when it opened in 1993. The Federal Correctional Complex in Florence, Colorado, contains 2 lower security facilities, 1 maximum security prison, and, since 1994, the Clockwork Orange-inspired U.S. Penitentiary Administrative Maximum. The steel and concrete citadels of the prison are rimmed by verdant hills covered in dense grass. But, inside the model modern maximum security prison, an old-fashioned rodeo of brutality plays out, where guards who call themselves the Cowboys are pitted against prisoners bridled by chains. On August 8, 1996, 4 guards punched, kicked, and body-slammed William Turner, according to an indictment filed November 2, 2000, in the U.S. District Court of Colorado. The guards contended that Turner, a slightly built 45-year-old robber, stabbed two of them with a sharpened toothbrush. Turner was charged with assault, bound with restraints, and thrown into a small holding cell. Unable to wash and covered in his own excrement due to injuries suffered in the beating, he pleaded unsuccessfully with medical staff over the next 4 days to be taken to the infirmary for X-rays and treatment. Turner also told anyone within earshot he didn't stab the guards, but was fearful they would be back to finish him off. "They're going to jump on me and kill me," he declared in one videotaped exchange with a medical technical assistant. "Look at me, man. I didn't stab nobody. I'll take a polygraph on it, man. I have never stabbed anybody in my entire time in this system." Turner's attack formed the foundation of the government's case. But Turner was by no means the first prisoner at Florence to suffer. Prisoners there were often falsely accused of assault, with fabricated incident reports created to cover up the brutality. In a series of hard-hitting articles in Denver Westward, writer Alan Prendergast revealed a pattern of misconduct, violence, and official acquiescence at Florence. As a result of media exposure, multiple lawsuits filed by prisoners, and complaints by other prison staff, the U.S. Justice Department conducted a 2.5-year criminal investigation. That probe quickly zeroed in on the guards called the Cowboys. The star witness for the Justice Department was David Armstrong, a former Florence lieutenant and confessed member of the Cowboys. Armstrong pled guilty in July 1999, in Denver's federal court, admitting that he and other Cowboys participated in retaliatory beatings against disruptive or problem routinely joked, bragged, and related tales of their abuse of inmates to each other. Armstrong also recounted how David Prune, 36, came up with the group's nickname during a confrontation with a prisoner who belonged to the Crips. "We have a new gang here," whispered Prune. "It's called the Cowboys." Armstrong, who faced 10 years in prison and a $250,000 fine, revealed in his plea agreement that the Cowboys formed in 1995 as a secret gang for dissatisfied guards. The Cowboys were angry because they felt prisoners assigned to the Special Housing Unit for assaulting staff were getting off too lightly. Their solution? Punch, kick, and torture chained and cuffed prisoners, then file false reports claiming the victims provoked the violence. Other staff were warned to keep quiet about the abuse. Officers who expressed disapproval of the Cowboys' actions were often threatened with physical harm, recounted Armstrong. Officers who did not support them could be at risk of harm from an attack by an inmate because Cowboys would delay or avoid providing help. By the time the Cowboys attacked Turner in 1996, the scope of their plan had broadened. Turner was a jailhouse lawyer, someone who prepares and files lawsuits and legal briefs for himself and other prisoners. 7 members of the Cowboys were indicted by a federal grand jury November 2, 2000. The guards were charged with 52 specific acts of misconduct against some 20 named prisoners from 1995 to 1997. It's unlikely that the number of the Cowboys, or casualties in their war against prisoners, will ever be known. The indictment provided a rare glimpse at how guards regularly abuse prisoners. Guards there kicked prisoners, smashed their heads into floors or walls, and mixed feces and urine in their food. Guards Mike Lavallee, 33, and Rod Schultz, 36, contaminated food served to prisoners with human waste several times. Lavallee and Prune tossed burning paper into a locked cell to justify spraying 2 prisoners with fire retardant. The guards were also charged with stomping prisoners' testicles. According to federal prosecutors, Lavallee told Armstrong and other conspirators they had the green light from prison authorities to take care of business. Lavallee and Schultz advised the Cowboys to lie until you die if questioned about their actions, and threatened payback for guards who didn't back them up. A news release from the U.S. Department of Justice explained the object of the conspiracy was to unjustifiably injure and physically punish restrained or compliant at the prison. In furtherance of that conspiracy, the charges revealed how guards falsified incident reports, and fabricated injuries and allegations of prisoner misconduct in order to falsely justify the use of force. The criminal action was hailed by officials as a positive step in the direction of ending abuse of prisoners by guards. Today's indictment demonstrates that no one is above the law, United States Attorney Thomas Strickland boasted in the press release. Those who deprive others of their constitutional rights while acting under color of law will be held accountable. Bill Lee, Assistant Attorney General for Civil Rights, added that the federal investigation and indictment proved the resolve of the Justice Department to ensure that prisoners aren't mistreated while in custody. This is the biggest indictment of Bureau of Prisons employees in recent history, if not ever, said Jess Dorschner, spokesman for the U.S. Attorney's Office in Denver. The charges came as no surprise to the Guards Union. In April of 1996, Dale Luzader, then president of the American Federation of Government Employees Local Union, wrote to prison officials, "We have employees that are engaged in acts of physical abuse against. Management knows this is happening and is condoning these actions. We understand that in some cases, supervisors are ordering the assaults." Chris Kester, a former Florence guard who worked at the prison from 1993 to 1997, said he and others tried to end the abuse. "We brought this up to management more times than I can count," Kester explained in a telephone interview with the Gazette, April 29, 2001. "The rumors were everywhere. These could not have done what is alleged without someone higher up protecting them. So far, no charges have been filed against prison administrators or bureau officials." Turner eventually received a $17,000 settlement in one of his civil rights suits against the federal government for the abuse he endured at Florence. That award, while not large by comparison to civil judgments generally, is significant because federal judges often dismiss claims of misconduct brought by people in prison. Ronnie Beverly, another former Florence prisoner, was repeatedly beaten by Lavalley, Schultz, and other cowboys while in the SHU in 1996. Beverly said brutality at the hands of guards was common in Florence. "It was a situation where your human rights were being violated and it was covered up from the top to the bottom," he told the Gazette. Not everyone believes these eyewitness accounts, however. "These people are in prison because they are cheats and liars," said Robert Leachty, an attorney representing guards named in one of Turner's lawsuits. "I think these charges are trumped up," he claimed. Leachty said prisoners frequently falsely accuse guards of abuse. "And it seems the indicted guards have other supporters. These are good officers," said Steve Browning, president of the local union at Florence and an employee there since 1995. He said the guards were falsely accused. "They are treated as if they are guilty," Browning lamented. "The prosecutors claim there is a big conspiracy, but I don't think these things happened that way." The former union leaders who complained to the Bureau of Prisons about the cowboys were tossed out in an election dominated by candidates who denied that anything wrong had happened. Under Browning, the union was turned into a support group for the indicted guards. They set up a legal defense fund and a separate account to provide assistance to the families of those charged while the case was pending. At Christmas, the wives of union officials dropped off gaily decorated gift baskets and succulent holiday dinners at the homes of the accused cowboys. Despite this support, evidence of their guilt was clear. In addition to Armstrong, 2 other guards offered to cooperate with federal prosecutors in exchange for leniency in their own pending cases. Jake Geiger and Charlotte Gutierrez are expected to be sentenced after the criminal trial of the other 7 cowboys concludes. Armstrong, first to break the code of silence, awaits sentencing for his part in the conspiracy at his New Jersey home. In 1998, Steve Mills, another former Florence guard, was sentenced to 33 months in prison for beating a prisoner. Gutierrez, the only woman involved in the conspiracy, pled guilty to kicking Harold Lane in the ribs. Lane, handcuffed and wearing leg irons, was picked up by another guard and thrown to the tile floor face first. After Gutierrez kicked the helpless Lane, a lieutenant told her to fix this, according to statements made in the plea agreement. She cleaned blood from the floor and walls, then hit her shins several times to make them look red and swollen. Her report claimed Lane provoked the violence by kicking her in the legs. Was the indictment and public exposure the last roundup for the cowboys? Probably not. Unlike the romanticized version of the shootout at the OK Corral where the Earps and Doc Holliday reputedly killed or disabled the leaders of a group of tombstone toughs who called themselves the Cowboys, the story of guards brutalizing prisoners won't be made into a feature film starring the latest crop of dewy-eyed actors. Neither the public nor law enforcement cares much about the safety of people in prison. If not for the self-serving cooperation of former guards who participated in the beatings and cover UPS, and the relentless reporting of a local writer, the Cowboys might still be riding M hard and putting M away wet at Florence, the rodeo in the Rockies. This article was written in 2001. Deliberate Indifference: State Authorities' Response to Prisoner-on-Prisoner Sexual Abuse. Joanne Mariner. 2. I've been sentenced for a DUI offense. My third one. When I first came to prison, I had no idea what to expect. I'm a tall white male, who unfortunately has a small amount of feminine characteristics. These characteristics have got me raped so many times I have no more feelings physically. I have been raped by up to men at a time. I've had knives at my head and throat. I had fought and been beat so hard that I didn't ever think I'd see straight again. One time when I refused to enter a cell, I was brutally attacked by staff and taken to segregation, though I had only wanted to prevent the same and worse by not locking up with my cellmate. There is no supervision after lockdown. I was given a conduct report. I explained to the hearing officer what the issue was. He told me that off the record, he suggests I find a man I would/could willingly have sex with to prevent these things from happening. I've requested protective custody only to be denied. It is not available here. He also said there was nowhere to run to, and it would be best for me to accept things. I probably have AIDS now. I have great difficulty raising food to my mouth from shaking after nightmares or thinking too hard on all this. I've laid down without physical fight to be sodomized. To prevent so much damage in struggles, ripping and tearing. Though in not fighting, it caused my heart and spirit to be raped as well. Something I don't know if I'll ever forgive myself for. A.H., Indiana prisoner, August 30, 19,961. The letter excerpted above was one of the first to reach Human Rights Watch in response to a small announcement posted in Prison Legal News and the now defunct Prison Life magazine. Having been alerted to the problem of prisoner-on-prisoner rape in the United States by the work of activists like Stephen Donaldson of the organization Stop Prisoner Rape, we decided to conduct exploratory research into the topic. When we put out a call to prisoners for information, we were deluged with letters. Rape, by prisoners' accounts, is no aberrational occurrence, instead it is a deeply rooted, systemic problem. It is also a problem that prison authorities do little to address. Rape plagues U.S. prisons because of a lack of attention or concern by prison authorities or politicians. In too many institutions, prevention measures are meager and effective punishment of abuses is rare. Nor does the criminal justice system protect sexually abused prisoners. Few prosecutors are concerned with prosecuting crimes committed against prisoners, preferring to leave internal prison problems to the discretion of the prison authorities. Similarly, prison officials themselves rarely push for the prosecution of prisoner-on-prisoner abuses. As a result, perpetrators of prison rape almost never face criminal charges. Internal disciplinary mechanisms, the putative substitute for criminal prosecution, function poorly in those cases in which the victim reports the crime. In nearly every instance evaluated for this study, prison authorities imposed light disciplinary sanctions against the perpetrator, perhaps 30 days in disciplinary segregation. Often rapists are simply transferred to another facility, or are not moved at all. Their victims, in contrast, may end up spending the rest of their prison terms in protective custody units whose conditions often approach those in disciplinary segregation, 23 hours per day in a cell, restricted privileges, and no educational or vocational opportunities. The federal courts have played an insignificant role in curtailing prisoner-on-prisoner rape. Because few lawyers are willing to litigate on behalf of prisoners, only a fraction of sexually abused prisoners bring their cases to courts, and because such cases are often filed by prisoners acting as their own counsel, they rarely survive the early stages of litigation. The cases that do survive hardly ever end in a favorable judgment. While there have been a few generous damage awards in cases involving prisoner-on-prisoner rape, they are the exceptions to the rule. In some, the failure to prevent and punish rape results implicates more than one government body. The primary responsibility in this area, however, is borne by prison authorities. Rape prevention requires careful classification methods, prisoner and staff orientation and training, staff vigilance, serious investigation of all rape allegations, and prosecution of substantiated allegations. At the least, it requires a willingness to take the issue seriously, to be attentive to the possibility of victimization, and to consider the victim's interests. Without these basic steps, the problem will not go away. Rape is not an inevitable consequence of prison life, but it certainly is a predictable one if little is done to prevent and punish it. Failure to recognize and address the problem and the perverse incentives created by legal standards, regrettably, is a problem of which we are happier not knowing the true dimensions. Overcrowding and the anything goes morality sure haven't helped. High-level state corrections official who spoke on condition of anonymity too. No empirical study has yet analyzed the prevalence of rape in prisons nationwide. But a number of smaller-scale, state or institution-specific studies have been conducted, many of which have found a high incidence of prisoner-on-prisoner rape. For example, a 1996 survey conducted by Professor Cindy Struckman Johnson in the Nebraska prison system showed that 22% of male prisoners had been pressured or forced to have sexual contact against their will while incarcerated. 3 of these, over 50%, had submitted to forced anal sex at least once. 4 Extrapolating these findings to the national level would give a total of over 140,000 prisoners who have been anally raped. 5 Official data tell a very different story. Only half of all state jurisdictions tabulate separate statistics regarding the incidence of rape, and those that do collect such data report that rape is an infinitely rare event. But since the causes of underreporting are well known to prisoners and prison administrators alike, a low frequency of reported cases is no reason for correctional authorities to turn a blind eye to the problem. Human Rights Watch surveyed the prevention practices of state and federal correctional departments and found that few departments take specific affirmative steps to address the problem of prisoner-on-prisoner rape. 6 Almost none of the departments who responded to our request for information had instituted any type of sexual abuse prevention program, and only a very few such as Arkansas, Illinois, Massachusetts, North Carolina, New Hampshire, and Virginia stated that correctional officers receive specialized training in recognizing, preventing, and responding to prisoner-on-prisoner sexual assault. 7 Similarly, not many departments had drafted specific protocols to guide staff response to incidents of assault. 8 High-profile class action lawsuits helped spur correctional authorities to take the problem of custodial sexual abuse seriously. Normally, the threat of litigation creates an important incentive for state authorities to come to grips with certain problems. Notably, the state of Arkansas, one of the only states that was able to provide Human Rights Watch with a concrete description of the training and orientation measures that it takes with regard to the problem, included a discussion of litigation and staff liability for prisoner-on-prisoner sexual abuse at the very beginning of its training curriculum on the subject. 9 Yet the legal rules that the courts have developed relating to prisoner-on-prisoner sexual abuse create perverse incentives for authorities to ignore the problem. Under the deliberate indifference standard, the prisoner must prove to the court that the defendant prison staff had actual knowledge of a substantial risk to him, and that they disregarded that risk. As the courts have emphasized, it is not enough for the prison to prove that the risk was obvious and a reasonable prison official would have noticed it. 10 Instead, if a prison official lacked knowledge of the risk, no matter how obvious it was to anyone else, he cannot be held liable. The incentive this legal rule creates for correctional officials to remain unaware of problems is regrettable. Indeed, In many lawsuits involving prisoner-on-prisoner rape, the main thrust of prison officials' defense is that they were unaware that the defendant was in danger. More generally, officials in such cases often argue that rape in their facilities is a rarity, not a serious risk. 11 They certainly have no reason, under the existing legal standards, to try to ascertain the true dimensions of the problem. The North Carolina pilot program. An encouraging exception to the overall absence of particularized attention to prisoner-on-prisoner sexual abuse can be found in North Carolina. In 1997, the legislature passed a law establishing a pilot program on sexual assault prevention in the prisons. 12 Covering only 3 units of the state prison system, the program is otherwise a laudable attempt at addressing the problem of prisoner-on-prisoner sexual abuse. It provides that the orientation given prisoners will include information on reducing the risk of sexual assault and that counseling on the topic will be provided to any prisoner requesting it. It also requires that the correctional authorities collect data on incidents of sexual aggression and develop and implement employee training on the topic. The program's rules on classification and housing are particularly valuable. They provide that all prisoners must be evaluated and classified as to their risk of being either the victim or perpetrator of sexually assaultive behavior. These classifications are to be taken into account when making housing assignments. In particular, prisoners deemed vulnerable to assault are barred from being housed in the same cell or in small dormitories with prisoners rated as potential perpetrators. Improper classification and negligent double celling. Among the goals of prisoner classification policies is to separate dangerous prisoners from those whom they are likely to victimize. At one extreme are supermax, or administrative segregation units, where prisoners with a history of violence or indiscipline are held. At the other are protective custody units where the most vulnerable prisoners are held. 13 Yet even between these extremes, the existence of various security levels, and the range of categorization alternatives within these levels, are supposed to allow prison authorities flexibility in arranging prisoners' housing and work assignments so as to minimize inter-prisoner violence and victimization. In the overcrowded prisons of today, however, the practical demands of simply finding available space for prisoners have overwhelmed classification ideals. Prisoners frequently find themselves placed among others whose background, criminal history, and other characteristics make them an obvious threat. In the worst cases, prisoners are actually placed in the same cell with prisoners who are likely to victimize them, sometimes even with prisoners who have a demonstrated proclivity for sexually abusing others. A Connecticut prisoner described how he was raped by his cellmate, a prisoner with a history of raping other prisoners. Was sent to the orientation block to be cellmate with another prisoner already occupying a double cell. I did not know at the time that I was to share a double cell with him, that he was a known rapist in the prison. I must point out that only a month and a half prior, he was accused of raping another man. On my 4th day of sharing the cell, I was ambushed and viciously raped by him. After being raped, I remained in shock and paralyzed in thought for 2 days until I was able to muster the courage to report it, this, the most dreadful and horrifying experience of my life. 14. The pressures of overcrowding facing so many prisons today mean that double celling is much more common than in the past, often with 2 men being placed in a cell designed for single occupancy while little care is taken to select compatible cellmates. Numerous prisoners told Human Rights Watch of being celled together with men who were much larger and stronger than them, had a history of violence, were racially antagonistic, openly threatening, or otherwise clearly incompatible. In such circumstances, rape is no surprise. Understaffing and the failure to prevent. The greatest preventive measure is posting staff areas that are high risk for assault. The reality, however, is that funding for prison administration doesn't provide for adequate patrolling. Prisoners are pretty much left on their own. A Virginia prisoner. 15. You know, when you look at the low numbers of staff around, who really owns this prison? High-level state prison administrator who insisted upon anonymity. 16. Another casualty of the enormous growth of the country's prison population is adequate staffing and supervision of prisoners. Texas, One of the largest prison systems in the country and one in which rape is widespread is known to be seriously understaffed. It is short an estimated 2,500 guards, what a high official in the Prison Guards Union characterizes as a staffing crisis. 17 Prison attrition statistics reportedly show that about 1 in 5 guards quit over the course of 2000. Paradoxically, lower numbers of correctional staff can lead to more ineffective monitoring by existing staff. Instead of redoubling their efforts to make up for their insufficient numbers, they are more likely to remain as much as possible outside of prisoners' living areas, because fewer staff makes close monitoring more dangerous to those employees who do make the rounds of housing units. Being at a disadvantage, they also have a stronger incentive to pacify rather than challenge the more dangerous prisoners who may be exploiting others. Poor design, especially common in older prisons, exacerbates the problem of understaffing and may provide opportunities for assaults. Explained one Florida prisoner, rapes occur because the lack of observation make it possible. Prisons have too few guards and too many blind spots. 18. Inadequate response to complaints of rape. An absolutely central problem with regard to sexual abuse in prison, emphasized by prisoner after prisoner, is the inadequate and, in many instances, callous and irresponsible response of correctional staff to complaints of rape. When a prisoner informs a guard that he has either been threatened with rape or actually assaulted, it is crucial that his complaint be met with a rapid and effective response. At the least, he should be immediately removed from the unsafe area and perpetrator, so his complaint may be made in a confidential manner. If the rape has already occurred, he should receive any necessary medical care, and physical evidence of rape should be collected. It is much more common, however, for prison staff to dismiss complaints of rape, or even take steps that further endanger the victimized prisoner. This prisoner's account is typical of many received by Human Rights Watch. Lieutenant B.W. had me identify the assailant in front of approximately 20 other prisoners, which immediately put my safety and life in danger as a snitch for telling on the other prisoner who sexually assaulted me. The prison officials trying to place me back in population after I identified the assailant in front of 20 prisoners clearly placed my life in danger because of the snitch concept. 19. Another prisoner who claimed to have been raped several times said that officers refused to take his complaints serious, telling him, "No way, you're not that good of a catch." A Texas prisoner said that after he reported that he had been raped, "I was pulled out and seen by Mrs. P, Capt. R, and Major H. I told my complaint and Mrs. P said that I was never raped, that I just gave it up." 20. Significantly, consensual sex is a rules violation in all prison systems, leaving the complaining prisoner with the possibility of facing disciplinary sanctions. Prison staff may also dismiss the victimized prisoner as merely engaging in gay behavior. A Texas prisoner who was raped by numerous other prisoners over a long period of time received the following response when he complained to staff. Defendant J.M., a security officer with the rank of sergeant, came to investigate the series of latest allegations. Defendant J.M. refused to interview the prisoner witnesses and told plaintiff that he was lying about being sexually abused. After plaintiff vehemently protested that he was being truthful, defendant J.M. made comments that plaintiff must be gay for letting them make you suck dick. 21. Some guards do respond to reports of sexual abuse, typically by moving the prisoner to a place of safety, often to a holding cell or what is called the transit area of the prison. Sometimes a medical examination is conducted and sometimes an investigation into the incident is opened. The problem is that these steps rarely lead to adequate measures being taken against the perpetrator of abuse. Rather than internal disciplinary proceedings or external criminal prosecution, the solution is typically found in isolating the two parties. Either the rapist or, more commonly, the complaining prisoner may be transferred to another prison. Serious investigation of abuses is all too rare. The basic procedures followed when a crime is committed outside of prison involving collection of physical evidence, interviews with witnesses, interrogation of suspects are much less likely to be employed when the crime involves prisoners. Failure to prosecute. As of this time I have almost 14 years in prison and have never heard of a prison rape case being prosecuted in court. I'm quite sure if a man committed a rape in prison and got 5 or 10 years time, prison rape would decline. An Ohio prisoner 22. Human Rights Watch surveyed both correctional departments and prisoners as to whether rapists faced criminal prosecution. The response was instructive. Although corrections authorities generally stated that they referred all or some cases for prosecution by outside authorities, they had little information regarding the results of such referrals. 23 Prisoners were much more blunt. They uniformly agreed that criminal prosecution of rapists rarely occurs. Judging solely by the direct accounts of rape we have received, criminal prosecution of prisoner-on-prisoner rape is extremely rare. Of the well over 100 rapes reported to Human Rights Watch, not a single one led to the criminal prosecution of the perpetrators. Even the most violent rapes, and those in which the victim pushed strongly for outside intervention, were ignored by the criminal justice system. Unlike rape in the outside community, rape in prison is a crime the perpetrator can usually commit without fear of spending additional time in prison. The following letter, from an official with the Minnesota Department of Corrections, suggests just how rare such prosecutions are. Questioned in 1997 as to specific instances in which prisoners had been prosecuted for raping other prisoners, he cited a case that occurred 12 years previously. You also asked if I was aware of any cases in which perpetrators of prisoner-on-prisoner sexual assault have been criminally prosecuted. I spoke with staff in our Office of Special Investigations and they informed me of one such case in September 1985. A prisoner was charged and pled guilty to criminal sexual conduct in the third degree. He received a sentence of 1 year and 1 day to be served consecutively to his original incarceration offense. 24. Although this response clearly indicates that rape prosecutions are rare in Minnesota, it is worth noting that almost all other state corrections department did not bring up any cases in which a perpetrator of rape in prison was prosecuted for the crime. Several said that they simply did not follow the progress of such cases. 25 The Missouri Correctional Authorities told Human Rights Watch in mid-1998 that 3 cases in the category forcible sexual misconduct were submitted for prosecution in 1996, 2 of which had been refused by the prosecutor and 1 of which was still pending. They noted, in addition, that there were no criminal convictions stemming from prisoner-on-prisoner rape or sexual abuse during the past 2 years. The case of M.R., a Texas prisoner, is a particularly egregious example of the failure to criminally prosecute rape in prison. Not only was M.R. raped repeatedly, the last time in full view of other prisoners, but he was nearly killed by the rapist, receiving a severe concussion, broken bones, and scalp lacerations. Desperate to see the man prosecuted, M.R. wrote both the local district attorney and sheriff explaining his strong desire to press charges. He even filed a grievance against the Texas correctional authorities requesting their help in securing the criminal prosecution of the rapist. None of his efforts made a difference. The prosecution was never instituted. Why are criminal prosecutions of prisoner-on-prisoner rape so rare? First, it is obvious that the severe underreporting of cases of abuse means that only a small minority of rapes are known to prison authorities, let alone to anyone outside the prison. Second, the failure of prison authorities to react appropriately to complaints of sexual abuse, including collecting physical evidence of rape and to properly investigate such complaints, means that the necessary fact-finding to support a criminal prosecution is lacking. Since local police do not patrol prisons, they rely on correctional authorities to gather the proof of crime. But another crucial problem is the low priority that local prosecutors place on prosecuting prison abuses. Although local prosecutors are nominally responsible for prosecuting criminal acts that occur in prisons, they are unlikely to consider prisoners part of their real constituency. Prisoners have no political power of their own, and impunity for abuses against prisoners does not directly threaten the public outside of prison. Since many state prosecutors are elected officials, these factors may be decisive in leading them to ignore prison abuses. Internal administrative penalties. M.R., the Texas prisoner who was nearly killed by his rapist, received another shock when he found out that the man was punished for the attack by spending a total of 15 days in disciplinary segregation. Judging by the reports received by Human Rights Watch, however, the punishment meted out against M.R.'s rapist is only unusual in that it was meted out at all, not in that it was lenient. Since it is rare for prison authorities to conduct the investigation necessary to make a finding of rape, perpetrators of rape facing disciplinary proceedings are usually charged with a lesser offense such as disorderly conduct. The following account is typical. Officers allowed another prisoner who was not assigned to my cell to enter and stay in my cell for 2 days with me. This was 2 days of living hell in which he raped and abused my body. He threatened to kill me if I let officials know. However, I began kicking the cell door anyway after the 2nd day and officials came to my aid. I informed officials of what had transpired the previous 2 days, but it was logged that I merely alleged that I had been sexually assaulted and raped. The prisoner was charged only with the disciplinary offense of threatening me. He got away with the sexual assaults, a much more serious offense, unpunished. 26. Perpetrators may spend a week or 2, or even a month, in the hole, rarely longer. Needless to say, when they return to the general prison population they may be primed for revenge. The lack of legal redress. Lawyers are, and with reason, terribly skeptical about the merits of prisoners' civil rights suits, most of which are indeed hooked up and frivolous. Chief Judge Richard Posner, U.S. Court of Appeals for the 7th Circuit. 27. Prisons are necessarily dangerous places. They house society's most antisocial and violent people in close proximity with one another. Regrettably, some level of brutality and sexual aggression among is inevitable no matter what the guards do, unless all prisoners are locked in their cells 24 hours a day and sedated. Justice Clarence Thomas, U.S. Supreme Court. 28. Like the public, many federal judges appear to view prisoners' legal claims with an extremely cynical eye. Either they disbelieve prisoners' complaints of abuse, preferring to focus their concern on the constraints under which correctional authorities operate, or they seem resigned to tolerating prison violence and exploitation. Not all federal judges are so insensitive to prison abuses. Indeed, a few worthy efforts have been made to put a stop to prisoner-on-prisoner sexual abuse, including the rulings in Lamarca v. Turner and Redman v. County of San Diego, but it is fair to say that the courts have not proven to be an effective champion of the sexually abused prisoner. 29. In theory, prisoners seeking recourse for violations of their constitutional rights may file a civil action in federal court. However, as described in Chapter 7 of the present book, the obstacles presented by legislation like the Prison Litigation Reform Act impede most of these suits from ever getting to court, and lower the prospects for a successful outcome once they get there. Yet, despite the small number of lawyers willing to litigate such cases, and the formidable obstacles of legislation like the PLRA, some prisoners do manage to file suit against prison authorities in the aftermath of rape. They typically assert that the authorities' failure to take steps to protect them from abuse violates the prohibition on cruel and unusual punishments contained in the 8th Amendment to the U.S. Constitution. But too often, such cases are dismissed in the early stages of litigation, with some judges going out of their way to excuse the actions of prison officials. The reasoning expressed by the court in Chandler v. Jones is typical. The case involved a prisoner who was sexually harassed after being transferred to a dangerous housing unit. In dismissing the case, the court reasoned that sexual harassment of prisoners in prisons would appear to be a fact of life. 30. Even while acknowledging the widespread nature of the problem, courts have been extremely reluctant to hold prison officials responsible for it. Their caution may, to some extent, reflect their belief that crucial policy and budgetary decisions affecting prison conditions are made elsewhere, and that guards and other officials should not be blamed for the predictable abuses that result. 31. By such reasoning, however, the courts have ensured near complete impunity for prisoner-on-prisoner sexual abuse. Finally, the rare case that does survive to reach a jury typically finds the prisoner plaintiff before an unreceptive audience. Consider, for example, the case of Butler v. Dowd, in which the jury found that 3 young prisoners had been brutally raped due to prison officials' deliberate indifference, but only awarded the plaintiffs the sum of $1 each in nominal damages. 32 or James v. Tilghman, in which the jury found that the prisoner plaintiff had been raped due to the defendant's negligence, but awarded him nothing, neither compensatory nor punitive damages. 33 In many other cases, moreover, juries have found in favor of the defendants despite compelling evidence to the contrary. Even the well-known case of Farmer v. Brennan, in which the transsexual victim of prisoner-on-prisoner rape prevailed before the U.S. Supreme Court, resulted in an unfavorable decision on remand to the District Court. The need for reform. Too many U.S. prisons reflect a wholesale disregard for prisoners' right to be free of violent rape and other forms of unwanted sexual contact. Reform is urgently needed. As many have noted, the state of a country's prisons is a telling indicator of its level of civilization. The barbarity of sexual assault in U.S. prisons reflects poorly on prison officials, on the courts, and on our society. Notes. In this excerpt, as in other excerpts from prisoners' letters included in this chapter, the author's idiosyncrasies of spelling and grammar have been retained. In addition, prisoners' names and other identifying facts have been withheld to protect their privacy. Email communication to Human Rights Watch, July 28, 1997. Struckman Johnson, Sexual Coercion, p. 67. The survey had a 30% return rate, so it is possible that overall rates of victimization were lower than 22%. But for several reasons, including the fact that staff and prisoner estimates of the incidence of these abuses correlated closely with the actual numbers found, the researchers believe that the 22% figure is reasonably accurate. Ibid, p. 74. Ibid, p. 71. Stephen Donaldson, the late president of Stop Prisoner Rape, made a similar estimate in 1995 on the basis of previous academic studies. He concluded that 119,900 male prison prisoners as well as many thousands of jail prisoners had been anally raped. Stephen Donaldson, Rape of Incarcerated Americans, A Preliminary Statistical Look, Stop Prison Rape, 7th ed., July 1995. Although few past studies have specifically examined correctional authorities' response to prisoner-on-prisoner rape, most commentators agree that little has been done to address the problem. See, for example, Robert W. Dumond, Prisoner Sexual Assault, The Plague That Persists, The Prison Journal, Volume 80, Number 4. Dumond notes, although the problem of prisoner sexual assault has been known and examined for the past 30 years, the body of evidence has failed to be translated into effective intervention strategies for treating prisoner victims and ensuring improved correctional practices and management. p. 407. Arkansas Corrections Authorities give a course designed to train correctional personnel to recognize and prevent potential sexual abuse among the prisoner population and to intervene quickly and efficiently in instances of suspected, actual, or ongoing abuse. The staff training manual on the topic is clear, detailed, and includes extremely useful guidelines as to how prison employees should react to instances of known or suspected sexual abuse. Arkansas Department of Correction, Sexual Aggression in Prisons and Jails, Awareness, Prevention, and Intervention. The manual itself says the course is 8 hours long, although the Training Academy manual says it lasts 4 hours. The Nebraska Correctional Authorities, in their response to our 1997 survey, stated that they were in the process of defining and implementing a formal sexual assault prevention program for both prisoners and staff. Letter to Human Rights Watch from Harold W. Clark, Director, Nebraska Department of Correctional Services, July 10, 1997. The department did not respond to any of our subsequent requests for information. Massachusetts is one of the few states that provided such a protocol, titled the Prisoner Sexual Assault Response Plan, which came into effect in October 1998. It covers the appropriate staff reaction to incidents of sexual assault, evidence collection, prisoner medical care, reporting procedures, witness interviewing, seeking of criminal charges, and psychological evaluation and counseling. Massachusetts Department of Correction, Prisoner Sexual Response Plan, 103 Doc 520. In a welcome step, the department trains certain staff members to be certified sexual assault investigators. The Federal Bureau of Prisons, charged with the management of one of the largest prison populations in the country, has also established a comprehensive protocol of this sort. It is designed to provide guidelines to help prevent sexual assaults on prisoners, to address the safety and treatment needs of prisoners who have been sexually assaulted, and to discipline and prosecute those who sexually assault prisoners. Federal Bureau of Prisons, Program Statement, Sexual Abuse/Assault Prevention and Intervention Programs, PS 5324.04, December 31, 1997. Connecticut has a sexual assault response protocol that was drafted in December 1996. The protocol covers staff response, evidence collection, medical treatment, mental health treatment, and prisoner housing placement. It is aimed at prison medical practitioners, however, rather than the correctional officers who are generally responsible for the initial response to claims of sexual abuse. Health Services, Prisoner Sexual Assault/Rape Protocol, December 11, 1996. Arkansas Department of Correction, Sexual Aggression in Prisons and Jails, Awareness, Prevention, and Intervention, P4. Farmer v. Brennan, 511 U.S. 825, 841. C. For example, Ginn v. Gallagher, 1994 U.S. Dist. Lexus 16669, Dreyer v. Roth, 1993 U.S. Dist. Lexus 209. North Carolina General Statutes, Chapter 143B 262.2. Human Rights Watch has previously documented abuses that occur in supermax prison units, including the fact that a lack of due process in assignment to such units means that prisoners may wrongly end up in them. See Human Rights Watch, Cold Storage, Supermaximum Security Confinement in Indiana. In other words, not all prisoners housed in supermax units are actually the worst of the worst, as proponents of such units like to claim. Indeed, Human Rights Watch has even found rape victims taking refuge in such units, having purposefully broken prison rules in order to escape to a highly regulated and secure environment. Letter to Human Rights Watch from B.J., Connecticut, September 23, 1996. Letter to Human Rights Watch, November 7, 1996. Human Rights Watch telephone interview, August 6, 1997. Jim Yardley, Escape Prompt Scrutiny of Texas Prison System, New York Times, January 11, 2001. Letter to Human Rights Watch from KM, Florida, June 18, 1999. Letter to Human Rights Watch from DA, Texas, September 18, 1998. Letter to Human Rights Watch from LT, Texas, February 19, 1997. Letter to Human Rights Watch from SH, Texas, September 10, 1996. Letter to Human Rights Watch from LL, Ohio, August 10, 1997. Texas was the only state that provided precise numbers regarding criminal prosecutions. In 1997, the Texas Correctional Department stated, since 1984, Internal Affairs has investigated a total of 519 cases. 4 cases have resulted in prosecution, with the guilty party receiving an additional prison sentence. Letter to Human Rights Watch from Debbie Miller, Executive Services, Texas Department of Criminal Justice, May 19, 1997. The department did not provide specific numbers in response to our 1998 and 1999 queries. In 1998, for example, Human Rights Watch was told that our Internal Affairs Division is not always notified by the prosecuting attorneys as to the outcome of these cases, We do not have the precise number of cases that are prosecuted and result in an additional prison sentence. Letter from Debbie Miller, Executive Services, Texas Department of Criminal Justice, July 29, 1998. Letter to Human Rights Watch from Terry Carlson, Adult Facilities Support Unit Director, Minnesota Department of Corrections, August 26, 1997. Typical is the response of Oklahoma correctional authorities. Our reports do not list the felony charges filed in district court, so we cannot confirm whether charges have been filed, but it does not appear to be routine. Letter to Human Rights Watch from James L. Saffel, Oklahoma Department of Corrections, June 5, 1997. Similarly, Rhode Island correctional authorities told us that they had no statistics on actual convictions. Letter to Human Rights Watch from Ashbel T. Wall, 2, Director, Rhode Island Department of Corrections, April 25, 2000. Letter to Human Rights Watch from J.C., Texas, December 16, 1998. Billman v. Indiana Department of Corrections, 56 F.3d 785, 790. For an instructive shock, change the word prisoners in that sentence to denote any other group: women, Native Americans, or homeowners, for example. Farmer v. Brennan, 511 U.S. 825, 839. C. Lamarca v. Turner, 662 F. Sup. 647, affirmed in part and vacated in part, 995 F.2d 1526, cert. Denied, 510 U.S. 1164, Redman v. County of San Diego, 896 F.2d 362, affirmed in part, revised in part, 942 F.2d 1435, cert. Denied, 502 U.S. 1074. Chandler v. Jones, 1988 U.S. Dist. Lexus 693, *3. It thus absolved the prison officials of responsibility, stating that the officials made the best of a bad situation. See, for example, McGill v. Duckworth, 944 F.2d 344. Ruling against two prisoners who were sexually assaulted, the court suggested that sexual assault was extremely common in the overcrowded jail under consideration, but that prison officials could not be blamed for the problem. It explained, the assaults were a result of the physical layout and overcrowding of the jail, both matters beyond the control of the defendant. Kish v. County of Milwaukee, 441 F.2d 901, 905. Butler v. Dowd, 979 F.2d 661. James v. Tilghman, 194 FRD 408. At the suggestion of defense counsel, the court revised the award, giving the plaintiff $1 in nominal damages. For Human Rights Watch, 2000. Corcoran Sex, Lies, and Videotapes. Willie Wisely. 3. I heard yelling and screaming. I heard batons hitting, Connie Foster told California lawmakers in July 1998, at a joint legislative hearing regarding guard brutality at Corcoran Prison. Foster, who worked at the prison from 1987 to 1996, recalled watching guards beat a prisoner lying defenseless and prone, his face pressed into the ground, hands cuffed behind his back. The hearings, which lasted 5 days, revealed a system out of control. They were just thrashing him. I walked away. It made me sick, Foster told the Sacramento Bee. Between 1989 and 1995, 50 Corcoran Security Housing Unit prisoners were shot by guards, 7 fatally. The number of prisoners brutalized in other ways is yet undetermined. The widely publicized killing of a prisoner, Preston Tate, gave rise to state and federal investigations of a prison where institutional violence was commonplace and killings of prisoners were routinely organized by guards for their macabre entertainment. On April 4, 1994, Preston Tate was shot dead by a Corcoran guard at close range with a 9mm assault rifle. Tate, serving a term for robbery, was intentionally put on the tiny shoe exercise yard with a rival street gang member. A guard later revealed in testimony that prison staff routinely staged cockfights between prisoners, then falsified reports to cover up the brutality. After the Tate killing, the horrified guard went to federal authorities with the story. A prison videotape caught Tate's murder in the yard. The tape made its way to television news shows across the nation, causing public outcry for an investigation. 7 years after the first unarmed prisoner was killed by a guard for fighting, and amid probes by the FBI and a local prosecutor, the Department of Corrections and Attorney General's office launched their own investigations into the shootings, violence, and cover ups at Corcoran. Not surprisingly, both concluded there was no widespread staff misconduct. It's clear investigations for the department are not adequate, Senator Ruben Ayala, D. Chino, chairman of the hearing, told the B. We must take a closer look at how they investigate problems and where that information goes. Even the department's own investigators were unhappy. The union and the governor's office ran the investigation. Jim Connor, a parole agent who supervised the department's team, told the Los Angeles Times. We would try to question a witness, and the union was there blocking us. They even told us how many interviews we could do, and our bosses in Sacramento backed them. This was no independent inquiry. It was just a sham. Investigators for the state called the probe an exercise in futility. I've been an investigator for 10 years, and no one has ever told me before that I couldn't talk to certain important people and couldn't pursue certain key leads, said Ben Eason, a supervisor with the department's investigation team. If this was a search for the truth, how can you establish those parameters? Governor Pete Wilson and Attorney General Dan Lundgren denied that the investigations were hamstrung. Lundgren called the complaints regarding the sham investigation a bunch of crap. Lundgren insists that the state investigation was purposefully limited so it wouldn't obstruct ongoing federal probes. We weren't going to duplicate or interfere with what the feds were engaged in. It's a matter of not screwing up another investigation, he told the Times. Federal authorities refute Lundgren's contention. They say their only mandate was to investigate the Preston Tate killing, and point out that there were plenty of other allegations of misconduct to occupy state investigators. During the hearings in July 1998, Connor denied saying that the department's investigation was a sham in interviews with the Times. But the Times explained that the reporter read the quote to Connor twice before publication, and Connor had agreed it was correct. Other investigators said they were afraid of losing their jobs if they testified truthfully. I was told to be careful of my opinions, one confided to the Times. No doubt about it, if I spoke my mind, there would be retaliation. That's the way it is. That's the nature of the beast. After spending $500,000 tax dollars on the state probe, only one person was singled out for discipline by the department's investigation. Richard Caruso, a former Corcoran guard who had provided key evidence about staged fights, shootings, beatings, and cover ups to the FBI, was docked pay for 90 days for firing wooden blocks at prisoners. The FBI told the Times they believe Caruso's punishment was an attempt to discredit Caruso and sabotage his relationship with the Bureau. Considering that Caruso was the central figure in the continuing federal investigation into Corcoran, prison officials had ample reason to be angry with him. Caruso, along with former facility captain Ralph Mino and former Lieutenant Steve Rigg, turned to the FBI in 1994 because their supervisors and corrections officials refused to listen. Their information led to the indictment February 26, 1998, of 8 Corcoran guards for violating the civil rights of prisoners. The 8 guards were charged with staging fights between gang rivals, falsifying official reports in an attempt to cover up those fights, and using a staged fight to kill Preston Tate. I'm a whistleblower, I'm not sorry for the action I took, Rigg testified at the hearing. I'm sorry I put my family through the horrors of the reprisals and harassment we've been subjected to. My career came to an abrupt end. I'm sorry I've been threatened with death or harm. I'm sorry my wife is frightened to sleep in our home at night and often sleeps on the bathroom floor fearing ambush. Brutality at Corcoran was common knowledge to those of us who spent time at the prison. In December of 1988, I left New Folsom's B facility on one of the first 5 buses bound for Corcoran. With a 1-year SHU term for assaulting 2 guards, I had reason to worry. We'd heard rumors of what could be expected for prisoners accused of assaulting a guard. It was hot that day. The air in the bus was stagnant, without circulation. We had no drinking water and sat crammed together, wearing dirty transportation jumpsuits without underwear or socks. Our hands were tightly cuffed to waist chains. Steel ankle restraints bit into bare flesh with every step. Located on a flat stretch of burned-out farmland laden with toxic chemicals in California's Central Valley, Corcoran was the first prison in the state to open a modern supermax SHU. The prison loomed at the end of a narrow highway in the distance, dancing in the heat. Most of the surrounding fields were barren, a few scraggly patches of cotton sprinkle the rock-hard, parched earth. By the time the bus rolled into the prison, we'd been chained in the bus 14 hours. A group of SHU baton-wielding guards stood in full riot gear next to the bus. They ran through marching drills before taking us off the bus. One by one, they grabbed us and tossed us from the bus. The guards screamed, "Don't look at us. Look straight up at the sun. We'll kill you if you look at us. This is Corcoran SHU." The guards separated and surrounded us. One jerked my head back, another leaned menacingly toward me, and another screamed into my face, showering me with his spittle. "You like hitting officers, huh, asshole?" he bellowed. "We've got something for you." I was hoping to make it to a cell alive, so when they peppered my kidneys and solar plexus with blows, I struggled to keep looking up. Corcoran's welcome wagon was composed of a group of rogue guards who called themselves the Sharks. According to the Los Angeles Times, in 1995 a busload of black prisoners transferred from nearby Calipatria prison was greeted by the Corcoran welcome wagon with the requisite pummeling. As the bus arrived, dozens of guards jumped to attention, performed a half-hour of warm UPS and cheers, then proceeded to beat the prisoners senseless. With tape obscuring name tags, the guards grabbed the shackled prisoners, jerked them off the bus one at a time, and ran them through a gauntlet of fists, batons, and combat boots. Prisoners with braids were held down while a guard cut their hair off. The abuse lasted over 30 minutes. One prisoner was thrown headfirst through a window, another smashed into a concrete wall. Some of the guards weren't scheduled to work that day, but nevertheless came to join the activities. A lieutenant helped cover up the incident, faking timesheets so it appeared many of the guards weren't at the prison that day. "I've seen guards beat, but nothing ever like that," Connie Foster would recount to legislators in 1998. "I couldn't watch it all. After it was over, I went to my car and threw up." When I arrived in 1988, only one of the 2 SHU facilities was open. It was dark before I got to a cell. I spent a few hours standing naked in a telephone booth-size holding cage, hands cuffed behind my back. The cells were concrete, save for the stainless steel toilet/sink combination. There was no mirror, locker, or electrical outlet. 2 concrete slabs for bunks lay side by side. No more than 18 inches separated them. Crude spaces carved out of the side of the concrete bunks served as shelves. I put my belongings, a half toothbrush, a small envelope of tooth powder, and pen filler in one of the spaces. When the door opened for yard, I went. In California, racial politics require you to go to yard in segregation or SHU. It's mandatory. It doesn't matter if you're scared or don't want to go. You go, or you're marked as a coward and subject to assault or stabbing. Corcoran's SHU yards are narrow triangles with high walls some 20 feet across at the wide end, 8 feet across at the narrow end, and maybe 30 feet long. The floors are unfinished concrete, slanted, and uneven. There's one combination toilet/sink, and one shower nozzle. Sometimes they worked, most of the time they didn't. The high walls reflected the burning sun onto the shoe yards, making them several degrees hotter than the outside air. You only go to the yard with your tier. Each building has 2 sides, 3 sections, and 2 tiers per section. Prisoners group by race in segregation unit yards. New arrivals are quickly told the rules: this is our area here. That's theirs. Cross the line and it's on. Sometimes the guards shoot the blocks first. Sometimes the line, explained an older con my first day in the yard. Prisoners exercise separately according to racial group. Handball, the one game available, is sometimes played between races, sometimes not, depending on the yard. Corcoran was a place of extremes. It was either extremely hot, extremely cold, or extremely wet. When the cold came, a thin layer of ice formed on the shoe yard floors and the toilet water froze. Hot, cold, wet, or dry, I went to the yard, exercised and played handball. A few weeks after I arrived, William Martinez, 30, was the first prisoner shot to death. He'd finished fighting with another prisoner and was walking away when a guard shot him in the back. I heard the shot, then the alarm. You never got too comfortable in one cell because guards moved you constantly. They stacked tiers with enemies, letting the fighters out first for yard. Everyone knew what was expected. If it happened to you, you had to fight. You might get shot either way. Southern Mexicans and whites stuck together. Northern Mexicans and blacks stuck together. Others picked sides when they hit the yard. I was lucky. I never got shot. Occasionally, bullet fragments and splinters of wood blocks hit me as they ricocheted off the concrete, but nothing serious. On one rainy morning, guards shot their 37mm guns 19 times on my yard. After a couple of months, the shoe yard walls showed pockmarks from bullets. Dark stains blotched the yard floors, some with long smears where a body was dragged away. When my shoe term was up, I was given an indeterminate term in newly opened Pelican Bay without charges, notice, or a hearing. They needed bodies to fill the new prison. My wife made a few calls, and I was on the next bus to a main line. I felt sorry for those with no one to help. Those like Eddie Dillard. Eddie Dillard was a 120-pound, 23-year-old first-termer. He came to Corcoran Shoe for kicking a female guard at Calipatria Prison. Roscoe Pondexter, a 6'7" former pro basketball player turned guard, knew Dillard was a marked man when he read the order to sell him up with Wayne Robertson. Robertson beat and raped black prisoners as a favor for the guards according to the Times, and prison records clearly indicated that he was a known enemy of Dillard. Serving life for murder, Robertson was known in the prison as the Booty Bandit. He told state corrections investigators that when shoe guards wanted another prisoner checked, they used him. He said he got extra food and tennis shoes in payment. I didn't know what wrong Dillard had done, but my superiors obviously wanted him punished, Pondexter told the Times. Everyone knew about Robertson. He had raped before and he's raped since. The Booty Bandit was just one of the tools of punishment that we used. Now out on parole, Dillard told the Times, they took something away from me that I can never replace. I've tried so many nights to forget about it, but the feeling just doesn't go away. Every time I'm with my wife, it comes back what he did to me. I want a close to the story. I want some salvation. But it keeps going on and on. Dillard has sued 4 Corcoran guards over the incident. Pondexter corroborates Dillard's claim that he was repeatedly raped by Robertson, as do multiple corrections investigative reports, and admissions by Robertson himself. Although they were from the same neighborhood outside, when Dillard arrived in prison Robertson propositioned him. Dillard turned Robertson down and they fought, according to the Times. Under department policy, the fact that they were listed as enemies should have prevented them from being placed in the same yard, let alone the same cell. At Corcoran, when Dillard was ordered to move to Robertson's cell, he told Pondexter, Sergeant Alan Decker, and Anthony Silva, another guard, that he and Robertson were enemies. Silva said, "It's happening. Since you like hitting women, we've got somebody for you," Dillard told the Times. The lights went out and Robertson grabbed Dillard. They struggled, Dillard pounded on the cell door, but no one came. Eventually, Robertson overpowered and raped him. Guards walked by 2 hours later, but just laughed at Dillard. Over the next 2 days, he was repeatedly raped. Finally, when the cell door opened, Dillard ran out and refused to go back in. A prison medical technician examined Dillard for sexual assault, but Dillard refused to snitch Robertson out. Robertson, however, openly bragged to a guard, "Yeah, I punked him," according to the Times. The guard reported the incident to Sergeant Jeff Jones and was told, "What do you want me to do with this? Nobody wants to do anything about it." An order to transfer Dillard to an outside hospital for a full rape examination was mysteriously cancelled. Dillard was moved to a different cell and warned by Decker not to make noise or they'd put him back with Robertson, Dillard told the Times. Pondexter later told FBI investigators he was routinely used by staff and administrators as an enforcer to intimidate and keep prisoners in line with terror. 7 guards and supervisors were investigated by the state, but no action was taken against them or the prison. State Prosecutor James John told the Fresno Bee that a Corcoran medical technician first tipped off state investigators about the cancelled rape exam for Dillard in 1997. The technician said the cancellation came from the prison's security squad, according to the Bee. Corrections records indicate the same squad covered up at least 13 other cases of excessive force at Corcoran. Corrections investigators told the Times their investigation of the Dillard case was stymied when the guards union posted flyers all over Corcoran prison telling guards they did not have to answer any questions without a union representative present. Even during the joint legislative hearings, state senators were met with a wall of silence. Guards refused to testify on advice of their attorneys, citing the so-called Peace Officers' Bill of Rights. Those civil statutes provide that anyone with the designation peace officer, like a prison guard, has the right to refuse to answer questions which might expose him to civil or criminal liability. Frustrated lawmakers promised to take a closer look at the statute for possible revision. Efforts to thwart investigation didn't end at the prison walls. In the town of Corcoran, guards went door to door distributing flyers, pleading for support for their indicted colleagues. During recent demonstrations inflamed by the brutality at the prison, guards staked out local parking lots and took down license numbers from protesters' cars. The union drew crowds of hundreds of guards and several Republican legislators at various gatherings organized to garner support. In the aftermath, information surfaced that the guards union spent over $27,000 for flyers denouncing Kings County District Attorney Donald Strickland as a friend of prison gangs because he prosecuted a guard for misconduct. Strickland was subsequently voted out of office. His opponent had been heavily financed by the union. Corrections Director Terhune approved spending more than $1 million of taxpayers' money to defend the guards charged by the federal grand jury, according to the Bee. Despite overwhelming evidence of their guilt, Terhune claims use of tax funds is appropriate because he's confident they are innocent. Governor Pete Wilson backed Terhune's decision. In the meantime, 6 of the guards are back to work at Corcoran, and 2 took early retirement. As chilling as the abuse and killings was the lack of any public concern or oversight that might have precluded the abuse's longevity. The fact that no one noticed seems to be the worst crime, Fresno attorney Catherine Campbell told the Times. Campbell represents the Tate family in their wrongful death suit. Corcoran was given license to act out the worst impulses of our criminal justice system, Campbell concluded. With the probability of further action by state legislators including the introduction of bills aimed at curbing the guards union's resistance to cooperating with investigators in the future, civil judgments against prison staff and the Corrections Department, the pending federal grand jury indictments, an ongoing FBI probe, and a second state investigation. It seems unlikely the department's problems will go away anytime soon. And that's a good thing. Unfortunately, it usually takes the loss of life or outrageous examples of brutality before the public and lawmakers take notice or demand changes in prison. This article was written in October 1998. Guarding their silence, Corcoran guards acquitted of rape. Christian Parenti. 4. The acquittal in November 1999 of 4 California prison guards charged with arranging for a young prisoner to be raped by Corcoran State Prison's notorious Booty Bandit was the result of a massive legal and political show of force on the part of the state's prison guards union, prisoners' advocates say. The 4 guards were facing 9 years in prison. State prosecutors alleged that in March 1993, the 4 Corcoran State Prison Security Housing Unit officers, led by SGT Robert Allen Decker, deliberately transferred prisoner Eddie Dillard to the cell of Wayne Robertson, aka the Booty Bandit, knowing that the younger, smaller prisoner would be raped. At trial, Robertson testified that he had indeed beaten and sodomized Dillard for 2 days because guards had said that Dillard needed to learn how to do his time. But the defense, led by 4 adroit lawyers and funded by the guards union, countered that the accused guards had no idea at the time that Robertson was a rapist. I agree that Wayne Robertson is a rapist and a thug, but that fact was not known to the floor staff, said defense attorney Curtis Sisk in his opening arguments. One of the officers told the jury that the first time he even heard of Wayne Robertson was in an article in the Los Angeles Times. The California Correctional Peace Officers Association, which paid the defendants legal costs and launched a media campaign to support them, is one of the state's most powerful lobbies. During the last election cycle, the group poured millions of dollars into state races, supporting candidates from both parties and waging a $2 million media campaign on behalf of Governor Gray Davis. We are obviously very pleased. The 4 guards and their families are the real victims here, said Union President Don Novi. With a pending federal trial and several criminal investigations of prison staff still open, the CPO left as little as possible to chance during the state investigation and trial. The union's publication, The Peacekeeper, encouraged rank-and-file members not to trust or speak with the FBI and state investigators. Critics of the union say this and quick intervention by CPO lawyers effectively shut down the flow of information at the source. As the so-called Booty Bandit trial approached, the CPO also turned to the public relations side of the political equation, targeting Hanford area residents with a slew of radio and TV ads full of menacing, tattooed convicts and brave guards walking the toughest beat in the state. And once arguments in the case opened, the CPO's concern was manifest in attendance of a steady stream of local chapter officials and union heavies. 4 prisoners' rights activists like Tom Quinn, a private investigator who specializes in researching cases against California jails and prisons, the presence of CPO honchos was just another example of how a code of silence is encouraged and enforced by the leadership of both the union and the Department of Corrections. Fundamentally, the claim that these guards didn't know that Robertson was a rapist is totally implausible, Quinn said. The SHU is a unique social experiment designed to generate information. Along with elaborate records and dossiers kept on all the prisoners, Quinn points out that guards have a relatively clear view into most of the SHU cells, both from the tier and from inside the control booth. Furthermore, adds Quinn, the cops are constantly working snitches. They know who's who. And they knew that Robertson was a rapist. Quinn's claims were affirmed by Connie Foster, who worked as a staff member at Corcoran in 1993. I heard about Robertson a week after I arrived, Foster said. Did Lockyer's office botch the prosecution? But despite claims like these, the state has had difficulty breaking the guards' silence. Among other things, say the union's critics, the CPO's massive campaign war chest has proved a valuable tool in discouraging local district attorneys from prosecuting cases against prison guards. The Dillard case, for example, was almost filed by the Kings County District Attorney, but Greg Strickland, who then held the county post, dropped the charges, citing lack of evidence. Many speculate that Strickland was also scared of the GPO. He had already crossed the group once, by prosecuting Corcoran guards involved in a 1995 beating incident. Sure enough, the union's wrath materialized during the next DAS race, in the form of a massive campaign donation to Strickland's opponent. In testimony before a state legislative committee, Strickland suggested the creation of an independent prosecution unit because, as he put it, my incumbent owes the GPO $30,000 worth of campaign contributions. That project was vetoed by Governor Davis, but a compromise was eventually struck, leading to the creation of a new Inspector General position, which is filled by gubernatorial appointment. Lockyer spokesman Nathan Barankine said that getting good investigations from local prosecutors and police forces in the small towns that house many of these prisons continues to be a problem. He said in the Dillard case specifically, there was no investigation after the crime was committed. Barankine did acknowledge that, in the wake of this case and the federal investigation at Corcoran, a number of changes have been implemented both by the legislature and the Department of Corrections. Besides the new Inspector General position, new shooting policies have been implemented at all state prison facilities. Still, Barankine conceded, the new policies are not a guarantee that this will never happen again. You can investigate until you're blue in the face, but you still have the question of who prosecutes it. Barankine said local district attorneys would normally prosecute these cases, but that in the small counties where most state prisons are located, to accept one of these cases would eat up everybody you have in the place, plus every red cent you've got to get one of these cases to court. The local DA could hand the case off to the Attorney General, but Barankine said by the time that happens, usually the AG's office comes in to pull together the pieces. DAS have their own investigators who work closely with local police right after the crime is reported. It remains to be seen if this new Inspector General will work the same way. While prisoners' rights activists sympathized with Barankine, they blamed Lockyer's office, specifically Deputy Attorney General Vern Pearson, for botching the prosecution. They say the state's strategy failed to make the code of silence and culture of terror at Corcoran central issues in the case. Based on his research of California jails and prisons, Quinn said the Booty Bandit trial was about much more than the fate of 4 prison guards. Clearly, part of what was on trial here was the guards' code of silence, the power of the GPO, and the culture of terror that defines life in California's maximum security prisons, he said. Quinn acknowledged that much of that was impossible to pursue in court when Judge Louis Besig disallowed conspiracy charges brought against the 4 guards. Our hands were tied by some of the judge's rulings and the fact that it took 5 years for this crime to surface and be prosecuted, Pearson told the Los Angeles Times. And it's never easy when your best witnesses of what really happened are felons and officers who have committed themselves. That sentiment was echoed by Barankine. Having the conspiracy charges thrown out by the judge was gigantic. That can't be quantified, he said. But Barankine conceded that there were all sorts of places along the way where things fell apart. The Bone Crusher. Activists say much of the blame rests with Pearson, arguing that his most crucial misstep was the handling of star witness Roscoe Bone Crusher Pondexter. A former guard and one-time professional basketball player, Pondexter testified against the 4 accused guards in exchange for immunity from prosecution. Pondexter testified that he was once a sadistic search and escort officer in the Corcoran SHU. He ran with a gang of guards called the Sharks and his specialty was to beat and strangle prisoners. We would show them the Corcoran way and tell them this was a hands-on institution, said Pondexter. He was eventually fired for brutality. But Pondexter's testimony was later picked apart by defense attorney Catherine Hart, who showed that Pondexter was on vacation the day Dillard was moved into the Booty Bandits cell. Pondexter had previously testified he was working that day. You had a faulty memory about that, didn't you? Asked Hart. Yes, Pondexter admitted, squandering much of his credibility in the process. Afterward, a vexed and embarrassed Pondexter was heard complaining to a friend that Pearson hardly prepared him for testimony, briefing and questioning him for only 25 minutes, just before he took the stand. Barankine refuted that claim, saying prosecutors spent a considerable amount of time preparing Mr. Pondexter for the trial. When asked about why they did not check records that showed Pondexter was not even working that day, Barankine said, "The defense had access to information we didn't have. We found out the same time did." Also missing from the state's case was much of the detail that had emerged during grand jury testimony and during last year's legislative hearings. According to both these inquiries, the story of the Dillard rape and ensuing cover-up went as follows: Dillard and Robertson, both members of the Piru Bloods, a Los Angeles street gang, though separated by a 20-year age difference, had first come into conflict at Tehachapi State Prison in 1992. There Robertson made sexual advances to Dillard and was rebuffed. Soon thereafter Robertson, already a documented jailhouse rapist, was transferred to the Corcoran SHU. In 1993, Dillard kicked a female guard and was sent north to Corcoran. In his grand jury deposition, Robertson told how SGT. Robert Allen Decker showed him a list of 4 proposed cellmates. Robertson chose Dillard and a few days later, while lying on his bunk, looked up to see the protesting Dillard being thrust into his cell by 2 guards. Dillard explained the rest when he took the stand. "Before I knew it, we were getting into it. We were tussling and he said he was going to rape me. I tried to fight him off but I couldn't. He raped me," said Dillard, his voice breaking. Dillard finally escaped the cell when guards came to take Robertson to an unrelated disciplinary hearing. Desperate, Dillard refused to re-enter the cell. Finally, Dillard told a guard that Robertson had raped him. The guard filed a report and passed it on to a sergeant, but the report was lost. Dillard was then examined by a prison medic, who saw no sign of rape. A doctor examined Dillard and ordered a rape kit, a full internal rape examination, but the order was quickly and mysteriously countermanded and Dillard was never properly examined. After getting a new cell, Dillard started sending administrative complaints, known as 602s, about SGT. Decker and the rape to officials in Sacramento. Records show that on June 16, 1993, Dillard suddenly withdrew his complaint and stopped his follow-ups. That was the same day that Decker signed in for a visit with Dillard on his new cell block. According to Dillard, Decker gave him a simple choice: drop the 602, or go back in the cell with Robertson. Little of this chronology was spelled out during the trial, though, and none of the defense witnesses seemed to remember much, all of which undermined the prosecution's case. "We went over everything, covered everything, a lot of documents," the jury foreman, who declined to give his name, told the Los Angeles Times. "In the end, there was just too much reasonable doubt. There just wasn't a lot of evidence that supported what the prosecutor was trying to prove. That was the fault of the prosecution," said prisoner's rights attorney Catherine Campbell. "My impression was that was on automatic, doing a job that was distasteful to him," she said. "He had no moral passion. The lapses, particularly the one with Pondexter, that sort of thing throws a witness off center." The Attorney General's office stood by Pearson, saying that he had inherited an impossible situation. "The football field is littered with Monday morning quarterbacks," said Barankine. He agreed that most right-thinking people should feel a sense of moral outrage based upon the evidence that we were privy to. Unfortunately, the jury was not allowed to hear all that evidence. This article was written in 2000. Our Sisters Keepers. Daniel Burton Rose. 5. While incarcerated in a for-profit prison in Arizona, Cristina Fuss says she was attacked by a guard, Ecobedo Rivas, as she stepped out of the shower in March 1997. Cristina told Prison Legal News that she was startled by the sight of him, standing there with his exposed erection in hand. Before she could think of what to do, she says, Rivas ordered her to bend over the bed in her cell and he raped her. She says he returned less than 2 hours later to repeat the act. Fuss was among 78 women exiled in October 1996, by the Oregon Department of Corrections. Because of overcrowding, the women were shipped to the Corrections Corporation of America's Central Arizona Detention Center in Florence. Predominantly a men's facility, CCA Florence lacked a separate disciplinary segregation unit for women. A medical quarantine room adjacent to the hospital area served as the improvised solution. According to a suit filed in Tucson by 5 women against CCA and at least 15 former or current CCA Florence employees, the all-male guard staff that watched over the improvised seg unit perpetrated sexual abuses with impunity for months. At least 5 of the women were returned to Oregon in August 1997, in an apparent attempt by the Oregon doc to hush the matter. That's when Berylee Bannister first contacted PLN. Berylee, one of the prisoners transferred back to Oregon, explains that the abuse started when a guard, Captain Newton, gave 6 or so women a marijuana joint. Hours later he returned with several other guards and notified the women their cells would be searched. Berylee says the captain told them that they could avoid charges for possession of contraband by performing a striptease for him and the other guards. Berylee said several of the women obliged, fearing additional time added to their sentences if they refused, or worse. The dancing, Berylee says, led to more aggressive behavior, from groping to oral sex and intercourse. A number of CCA Florence guards were eventually placed on administrative leave as a result of an internal CCA investigation of the abuse allegations. Fuss told PLN that shortly before she departed for Oregon, a CCA guard told her there were currently 27 such complaints filed. Bannister estimates that up to 50 CCA Florence guards were involved in all, with offenses ranging from perpetrating the abuse to covering it up. In U.S. prisons, such degradation is not uncommon. A July 20, 1995, incident in one of Washington, D.C.'s jails offers another glimpse of the seamier side of corrections. As D.C.'s Seoul station WHUR-FM was piped over the jail's public address system, several female prisoners began to dance and strip on tables in the common area of the block called Southeast 1. A crowd of prisoners and guards gathered to watch. Among them was Sunday Dascalia, a naturalized Greek immigrant and exotic dancer from New York City who was in the jail facing cocaine charges. Dascalia later described to the Washington Post how, swept away by the festival atmosphere, another prisoner exclaimed, "Sunday's a dancer too." But Dascalia says she wanted nothing to do with the exhibition and retreated to her cell. According to Dascalia, the captain in charge of the block, Yvonne C. Walker, instructed a crew of prisoners to force Dascalia back to the exhibition. "You're going to make mad," one of the prisoners warned. Dascalia relented. "I didn't want any trouble," she recalled. She did the striptease, in which another prisoner also undressed and poured baby oil on a nude Dascalia. Although jail staff were present, none reported the incident. D.C. jail officials eventually heard about it through a prisoner. And this incident occurred just 3 months after a federal jury found the D.C. Department of Corrections liable in a sexual harassment suit in which the department eventually settled for $8 million. Sexual abuse of prisoners by guards is not particularly new. What is striking today is the extent of the abuse, in both men's and women's prisons, and the near-total lack of interest among prison administrators in stopping it. No state or federal government entity collects reports of prison rape, so exact numbers are difficult to gauge. But with a barrage of high-profile individual and class action suits, and the stunning exposé of rampant sexual abuse in American prisons as disseminated by a 1996 Human Rights Watch report on the topic, sexual abuse appears to be endemic to prisons across the nation. Susan Feaster, an expert witness on sexual abuse who has testified for prisoner plaintiffs in 5 states, estimates that 70 to 80% of the general female prison population has experienced sexual abuse during and/or previous to incarceration. The effects of sexual abuse on victims can be debilitating, resulting in depression, frequent headaches, insomnia, trouble concentrating, low confidence and self-esteem, and isolation from others. These symptoms can be especially acute when the rapist is a guard and the victim is forced to live each day with the fear that the abuser will violate them again. Few such cases are reported. And if they ever come to trial, they are often framed as he said/she said, in which the issue central to the case is the credibility of the aggrieved prisoner. According to court testimony, Tanya Duran was raped by a guard named Danny Torres while she was incarcerated in the disciplinary seg unit of another CCA prison, the Western New Mexico Correctional Facility in Grants. Duran, who had been incarcerated for shoplifting, said the seg unit was isolated and poorly monitored. She testified that Torres took advantage of the isolation, raping her when he came to deliver a meal tray to her cell. In a civil trial in the summer of 1997, Duran demanded more than $1 million in damages from Torres and CCA. Torres acknowledges only that he and Duran had sex. He claims Duran wanted it. The defense strategy was to elicit testimony from Duran that she had been raped before more than once and then twist that into a seed of doubt to plant in jurors' minds. The defense strategy worked. Though no one disputed that sex took place, the 8-woman federal jury awarded Duran nothing. Paul Kennedy, Duran's attorney, recounted, "There was a lot of hostility from the jury because was a prisoner." Former Michigan prisoner Sadia Zoe Ali asks in a November 1996 Prison Life article, "Will somebody please tell me why the fuck it's so hard to believe these women?" As Sadia explains, any prisoner who steps forward to report abuse risks retaliation from the doc and personal vengeance from the Blue Gang. Because of that, says Sadia, reporting rape to prison officials is a choice fraught with negative consequences. Bannister, for example, says that soon after she spoke to CCA's investigators at Florence, she was attacked by 3 guards, led by a female guard named Collins, who beat her. The guards accused Bannister of being responsible for their friends being fired. And, assuming that Bannister had been raped, the guards aimed their kicks at Bannister's stomach, saying they would force her to abort if she was pregnant. Later that same day, according to a statement Bannister made after her return to Oregon, Collins sprayed mace under her cell door. Sexual assaults against male prisoners by male guards similarly receive little, or no attention. In these cases, homophobia can be an extra strike against the victim. According to a June 1997 finding against the District of Columbia's Department of Corrections, for example, prison administrator L.C. Jones expressed disbelief when presented with the charge that one of his male guards sexually harassed a male prisoner. Jones, who had charges of sexual harassment pending against him as alleged by both female guards and women prisoners, cited the accused guard's age of 60 and testified in court, "I'll give you the fact that maybe he might be turned on by that fag, I don't know. I just do not. I find it hard to believe." Jones was promoted to deputy warden soon after the incident took place. Prison administrators may simply ignore allegations of sexual abuse. Several women who allege abuse at CCA Florence report that they sent numerous letters complaining of the abuse to both Warden Crandall and Assistant Warden Alfred Scott. They put blinders on. They didn't care, says Jackie Scott, who claims she was sexually harassed by a male nurse at CCA Florence. When CCA was eventually forced by media attention in Oregon to investigate the claims of sexual abuse at CCA Florence, the women prisoners report that investigators were insulting and abusive. Bannister additionally states that she was offered $100 by several CCA administrators if she would keep quiet. Quita Graham, a guard who witnessed the July 95 striptease in D.C.'s jail, told the Washington Post that she knew she should have reported the incident to prison officials but was afraid of other guards labeling her a snitch. "Nobody wants to work with you once you break the code of silence," Graham explained. She added, "If an inmate is attacking you, you might be waiting for assistance for a very long time." This article was written in February 1999. Not part of my sentence. Silja J. A. Talvi. 6. Annette Guzman White, a 32-year-old minimum security prisoner incarcerated on a second-degree burglary charge at the Washington Correction Center for Women, is eager to get out of prison. It's something that could probably be said of most of Washington state's 15,000 prisoners, just slightly over 1,000 of whom are women. But Guzman White says that her time at WCCW has put her through a kind of emotional hardship she says she wouldn't wish on anyone. She alleges that a male prison guard, Joseph Soleta, preyed on her vulnerabilities and coerced her into a sexual relationship. Soleta, who was fired in 2000 but not charged with a crime, has been accused by at least 2 other women of rape or sexual assault. One of those women, Rosie Hammond, alleges that Soleta forcibly raped her in September 2000, information, which only emerged after prison investigators approached each of the women separately to confirm an anonymous report that Soleta was having sex with prisoners. Even then, the women were not eager to share the information, and Guzman White initially insisted she had no sexual contact with Soleta whatsoever. "I denied everything. I was scared of what would happen," she now admits. Guzman White told of the rape in September 2000, after prison investigators repeatedly reassured her that she would not be punished for telling the truth. Since then, Susan Luna, a former prisoner at WCCW, has alleged that she was sexually harassed and molested by Soleta. And when those allegations came to light, another prisoner came forward in November 2000, with a confidential written statement to the doc that Soleta had repeatedly sexually harassed her when he first began working at WCCW. While she has not filed claims for damages, she alleges that Soleta told her, "I'm in hog heaven up here," in reference to his job at the women's prison. On one occasion, she writes in her sworn declaration, "He pulled his penis from his pants and said, 'You want this, you know it?'" Soleta did not return calls for comment. And WCCW prisoner Tamara Smith has alleged sexual harassment and physical contact of a sexual nature involving various other male guards while she was showering in the prison. A 5th prisoner, Danielle Rivas, says she was coerced into having sex numerous times with a cook at WCCW. All 5 women filed claims for damages against the state. Consensual sex is okay. Tim Tesh, an attorney with the Seattle law firm Brown and Ressler representing the prisoners, says that a mediation between him and the doc in July 2001 was a joke, and that in the meantime, Guzman White endured punishments at WCCW, including placement in isolation for a minor infraction. His office now plans to team with nonprofit legal agencies to file a class action lawsuit. Tesh hopes that the lawsuit will result in monetary payment to the prisoners and improvements in the prison culture at WCCW to prevent similar incidents from happening in the future. What is perceived to be consensual sex between correctional officers and prisoners is okay and continues to be tolerated in the prison, says Tesh. It's part of the code of silence. But prison officials say nothing could be further from the truth. As an agency, we have a no-tolerance policy for this type of behavior by dock personnel, volunteers, or contractors, answers WCCW Superintendent Belinda Stewart. I take the time to tell new employees, very bluntly, that I absolutely have a no-tolerance policy for this kind of behavior. We have a job to do as professionals to keep the environment safe for the people that are incarcerated within our system, and when staff overstep boundaries, it can make this kind of environment unsafe and dangerous to be in. As a woman myself, she adds, I don't want people overstepping boundaries with me, and so it's important that we keep this environment safe. Indeed, the dock's official zero-tolerance stance on sexual relations between guards and prisoners helped to usher in legislation which went into effect 2 years ago, criminalizing rape and other forms of sexual contact consensual or not between guards and inmates. At the urging of the dock, Washington's Sexual Offenses chapter of the Criminal Code was revised to find a person guilty of a felony when that person, whether employee or contract personnel, was proven to have had sexual intercourse with a person under correctional supervision. Sexual misconduct of any other kind is classified as a gross misdemeanor. Provisions in the law also specifically ensure that prisoners will not be penalized for disclosing information about sexual contact or abuse. Under revised state regulations, prison guards would immediately be suspended, investigated, terminated from employment in the case of a preponderance of evidence of sexual misconduct. That is the process that is intended under the law, explains State Senator Jeanine Long, who sponsored the Senate bill to criminalize sexual relations between guards and prisoners. If is following it, everything should work out in the proper way. It's a two-way street, adds Senator Long. The officers have authority and ability to influence where a person is held and how long they're held, and prisoners have the ability to cause a correctional officer to be investigated and possibly lose their job. We attempted to balance those two areas. Quiet firings and resignations. In the 2 years since the law went into effect, investigations of sexual misconduct and terminations of employment have occurred. In these most recent cases, WCCW confirms that the doc no longer employs Soleta, but Stewart indicates that there have been no other employment terminations related to sexual misconduct allegations. And in the interim, the state has paid out hefty sums of taxpayer dollars by way of settlements to some prisoners who alleged sexual abuse in various prisons before and since the law was passed. In total, according to information obtained from the Office of Risk Management, nearly $500,000 has been paid out in settlements since 1998, including a $150,000 settlement to Heather Wells, a WCCW prisoner who alleged she was raped by guard Michael Stevens. She endured punitive segregation when she came forward with her allegations, and became impregnated by the rape. Stevens, who initially denied any sexual contact with Wells, was proven to be the father through paternity testing. He later tried, unsuccessfully, to gain custody of the child. Stevens was never charged with a crime, although he did resign from his position. And while some prison guards may be losing their jobs, or are being pushed toward resignation, they have not faced criminal charges. The two recent exceptions involve female guards. Sergeant Monica Secured, who had worked at the Clallam Bay Corrections Center for 14 years, resigned from her position in December 2000, for having relations with a male prisoner. Secured entered a guilty plea to custodial sexual misconduct in February 2000, and was sentenced to 1 year in jail, with all but 10 days suspended. In October 2001, Flora Pellecchio pleaded guilty to 1 count of custodial sexual misconduct. Pellecchio, a librarian at the Washington Corrections Center in Shelton, was caught by guards having sex with Lori Campbell, a convicted rapist, in the library storeroom. What we need to see are aggressive prosecutions, and the people who actually perpetrate these crimes brought to justice, emphasizes Trine Christensen, a research associate at Amnesty International USA who helped to write Abuse of Women in Custody, a state-by-state survey released by AIOSA in March 2001. It's a terrible sign to send to other correctional officers who work within these systems that you can do these things and go unpunished, or get a slap on the wrist, or get let out through the back door. Superintendent Stewart forwarded Soleta's file in November 2000 to the Pierce County Prosecutor's Office in Tacoma. Despite the investigation that resulted in his firing, the local prosecutor's office opted not to file charges in late June, when Deputy Prosecutor Mary Robnett cited a lack of corroborating evidence to ensure conviction. Senator Long criticized the decision not to prosecute, telling the Seattle Times on June 21 that he guards, in these cases, have tremendous power and authority over the inmates. Tesh expressed outrage at the reasoning of the prosecutor's office, and promptly filed a civil rights complaint with the FBI and the U.S. Attorney's Office. No significant action has yet been taken on those complaints. The coercion game. To Guzman White, the memories of the encounters in August and September 2000 still haunt her. She explains, in halting terms, how she was coerced into a sexual relationship with the guard on her second day in the minimum custody unit where he worked. After approaching Guzman White earlier in the day, Soleta asked to talk to her after midnight when most prisoners are asleep to ask her a few questions. Then, after midnight, Soleta began a several-hour-long game of seduction and insistent sexual behavior, asking her if she had ever been with women while in prison, and asking her what her nationality was. "I've never been with a Hispanic woman before," Guzman White remembers Soleta saying. Frightened and confused, Guzman White recounts that she tried to fend off his advances and requests for oral sex several times in those early morning hours. Eventually, Soleta took her to a staff break room where, she says, she finally gave in to his insistence to have sex. "I was feeling vulnerable. I felt like he had something over me," she says. "I knew he could make my time harder." When Soleta returned after a vacation, he resumed sexual contact with Guzman White. "It was a situation," she says, "which left her feeling guilty, confused, scared." She says that he warned her not to say anything about the situation lest she jeopardize his job. Other situations over the past few years involving the sexual abuse and rape of female prisoners by male guards have involved more overt threats, including a case in 1998 where, according to internal documents, prison guard Robert Perry had sex with a mentally ill prisoner at WCCW. Perry told her that if she ever said anything about the sexual contact that she would be taken care of. Perry, who was subsequently dismissed, also threatened the prisoner that he would kill anyone who said anything about the incidents. Seattle attorney Rebecca Rowe also won a $50,000 settlement for Valerie Stone in April 1999, for a 1994 rape alleged against now-deceased prison gynecologist Dr. Dale Huber. Stone alleged that Huber raped her during a pelvic exam. Dr. Huber resigned, but he was not charged with a crime. There were a number of other similar incidents at McNeil Island Correction Center, says attorney David Jerk, of the Seattle law firm Jerk & Tiziano. Jerk represented Brenda Pierce, who won a $50,000 settlement in 1998 involving a rape allegation against guard Jeffrey Donaldson. Jerk says that Donaldson threatened to get Pierce transferred back to WCCW if she refused sex, where she would serve more time than at MICC. She was on a special 6-month work program at MICC, called the Work Ethic Camp, and the threat apparently terrified her into having coerced sex with Donaldson. "Most correctional officers are good and dedicated people, although they're underpaid and get no respect," stresses Jerk. But part of what's going on is the power and control issue. When you want to dominate and rape women, what better than being a prison guard? The problem of recognizing and addressing the prevalence of sex behind prison walls is compounded, Jerk says, by the upper echelons of the dock, wherein us vs. them mentality rules. They've got this real attitude that they're above the law. They've got a tough job, they know how to do it, and outsiders shouldn't try to make suggestions or tell them how to do it. They're resistant to change. Donaldson maintained his innocence and was never charged with a crime, despite a settlement for $22,500 involving another female prisoner, Tricia Meckley, who made similar allegations against him. In a sworn declaration filed in Thurston County Superior Court in 1997, Donaldson provides a rare glimpse into the prison milieu, and provides a clue as to why such sexual misconduct is possible in this environment. "There was a great deal of prisoner sex," wrote Donaldson in his declaration. "Sexual activity occurred regularly behind the gym, behind the kitchen, and in the bathrooms. I recall a case where one prisoner was sold to another for stamps. Drug smuggling and drugs for sex exchanges were major problems." Donaldson mentions investigating sexual contact between a cook and a female prisoner, and names 2 guards, Sergeant Long and Officer Ralph Wilkins, whom he knew to be engaging in sex with prisoners. He also refers to a widespread rumor regarding a physician's assistant who serviced the work camp at MICC, and who was doing more than gynecological examinations. He wasn't wearing gloves, he was feeling prisoners up. Women were being called in for exams without explanation. The state has that declaration, Jerk points out. "As far as I know, there's been no official investigation of that." Records procured via a public disclosure request show that the dock disciplined at least 15 employees for sexual harassment or assault from January 1995 to January 2001 at McNeil Island Corrections Center. The kind of environment described by Donaldson's declaration at McNeil's WEC over the past several years may have contributed to a recent DOC decision to transfer the remaining women who numbered no more than a dozen from the WEC to WCCW. It is unclear if the women, who were transferred on April 6, 2001, will still be eligible for the shorter sentence granted to eligible prisoners who were to participate in the kind of job and life skills training touted by the WEC program, as the DOC would not comment on the subject. Roughly 40 men remain enrolled in the program. JUR considers the transfer of the women to the prison from WEC to be utterly outrageous. They can't control their own staffing and personnel problems, so they have to punish the women that otherwise would be qualified and deserving of something like this, JUR says emphatically. Protecting women prisoners. Statewide, the DOC employs 2,755 prison guards, 78% of whom are male. At WCCW, says Superintendent Stewart, 57% of guards are men and 43% are women. The national average of male guards working in female prisons is around 41%, according to a 1997 survey. Some human rights organizations and many prisoners' advocates call for women's prisons to be predominantly or entirely staffed by women, and where that is not possible, for male guards to be disallowed from unsupervised access to women's living quarters. The standard minimum rules for the treatment of prisoners, a provision in the first United Nations Congress on the Prevention of Crime and the Treatment of Offenders states, women prisoners shall be attended and supervised only by women officers. This international law, also called Rule 53, was adopted on August 30, 1955, and has been accepted by all European Union countries. Moreover, says Trine Christensen of Amnesty International USA, male guards were rare in U.S. women's prisons until the 1970s, when employment anti-discrimination laws were applied to prisons. But the call for exclusively female-staffed prisons or for increased supervision doesn't go over well with state officials and prison administrators. How many layers of supervision do you impose? It isn't workable, says Senator Long. We have women guarding men in other, so are we going to say that we can only have men guarding men? I think we'd get into some discrimination issues if we did that. Guzman White argues that more careful supervision of all prison guards would make the lives of female prisoners better and safer than an all-female staffed prison. She cites multiple instances of female guards who sexually and/or physically harass female prisoners. I think we have a nice female complement at this institution, and it's about people acting professional in the workplace, answers WCCW Superintendent Stewart. There's no scientific study to say that if we had more females here that wouldn't happen. The bottom line, says Tesh, is the fact that no prisoner regardless of their crime or gender deserves to be subjected to violations of basic human rights. Rape is cruelty. Sexual assault is cruelty, he stresses. A zero-tolerance policy doesn't mean anything if you have no enforcement of that policy. A shorter version of this article first appeared in These Times, October 2001. Make it hard for them, a hunger strike against the INS. Mark Dow. 7. Nabil Solomon believes that accepting a tray of food from his jailers means accepting what he calls his illegal detention by the Immigration and Naturalization Service. Solomon has argued that it is a violation of his First Amendment right to expression and his 14th Amendment right to privacy for jail officials to force-feed him. The INS responds that while Solomon may have constitutional protections, these are limited when weighed against the government's interest in preventing hunger strikes and preserving the life of INS detainees. Solomon is just one hunger striker, but his case has national implications for the INS's management of its ever-increasing, and increasingly frustrated, population of detainees. The INS currently holds over 20,000 detainees nationwide in its own service processing centers, in privatized contract facilities, and in hundreds of local and county jails. The federal mandatory detention laws of 1996, which resulted in lengthy detention for thousands of legal residents convicted of often minor crimes, have transformed the agency into a mini-BOP, according to one INS official, referring to the Federal Bureau of Prisons. The average daily population of INS detainees just before the 1996 laws was about 8,000. Local politicians around the country have been more than willing to help ease what that INS official calls significant growing pains. In early March 2001, for example, the Etowah County Detention Center in Gadsden, Alabama, where Nabil Solomon is in custody, announced an $8.4 million expansion. The jail currently has 376 fixed beds, and, with the use of plastic stackable bunks or boats, its population is usually in the 400 range, according to Chief of Corrections Wes Williamson. Between 70 and 100 of those beds are contracted by the INS. Once construction has been completed, Etowah County will house 324 INS detainees at a rate of $30 to $33 per detainee per day, well below the $55 per man-day national average. Etowah County Sheriff James Hayes told the Gadsden Times that the old INS contract has already helped the county pay for new vehicles, training, and equipment. The new 15-year contract, he says, should raise $120 million in revenue. As for the INS, the agency seems poised to hold out Etowah County as one of its flagship facilities. Even INS detainees like Solomon who are frustrated by their detention have few complaints about conditions per se at Etowah County. The jail opened in 1994 to replace its outdated predecessor across the street. The new jail's conditions are the direct result of a consent decree that followed a 1988 class action suit against the old jail, according to attorney Tamara Sirwer of Atlanta Southern Center for Human Rights. This is no small matter for the INS, which holds over 60% of its detainees in county jails. After years of criticism, the INS recently announced that its long-awaited detention standards would apply to all of those contracted jails. According to one Justice Department official, only 3 of 40 local facilities audited last year actually complied with all of the national standards. Etowah County complied, and Chief Williamson, known for his respectful attitude toward prisoners, says his jail is ready to handle some of the INS's more difficult cases, including hunger strikers as well as long-term or post-order detainees, whose deportation cannot be carried out easily, if at all. Solomon, a 40-year-old Egyptian, qualifies as one of the INS's difficult cases. He entered the United States legally and lived in New Jersey for 9 years before being detained, having married and later divorced a U.S. citizen. He drove an 18-wheeler for a living, and he has 5 children, 2 of them U.S. citizens as well. The INS eventually labeled Solomon's marriage fraudulent. He has been detained now for almost 4 years, including 1 year in Gadsden. His case is complicated, but it illustrates the kind of frustration that leads so many INS detainees to protest. According to the U.S. government, Solomon is wanted by the Egyptian authorities for his alleged connection to a group which is held to be responsible for the 1981 assassination of President Anwar Sadat. Solomon argues that he is a victim of mistaken identity, based on a confusion of names. In May 2000, the Board of Immigration Appeals granted Solomon deferral of removal under the Convention Against Torture. This means that, based on the likelihood that he would be tortured if returned to Egypt, the United States cannot return him there, regardless of the truth of his identity. Solomon remains detained, however, because the INS maintains that he is a danger to the community and unlikely to appear for proceedings. This decision appears to stem from earlier U.S. government allegations that Solomon had connections to persons involved in the 1993 World Trade Center bombing. An immigration judge called these allegations not sustainable and unconvincing. The government itself admitted back in 1997 that it had abandoned that line of inquiry and, more recently, that Solomon was never charged with any terrorist activity in the United States. Solomon has never been charged with any crime in this country. Nevertheless, the government continues to use those allegations against him in its most recent court pleadings. Atlanta District INS officials, who have jurisdiction in Solomon's case, did not return calls seeking their explanation for continuing to hold Solomon as a danger. While Solomon himself did not raise the possibility of anti-Arab bias within the INS, when I asked him about that possibility, he told me that after the World Trade Center bombing convictions, many in New Jersey's Arab community said the evidence must have been fabricated. Solomon defended the integrity of the American justice system to them. But after I got in INS and I see how the system work, he says, and how they make me a terrorist, his faith has been shaken. Although Solomon has agreed to be deported to any available third country, and to pay the expenses himself, a Justice Department official familiar with the case acknowledges that we can't find anywhere else to deport him. These are the circumstances which have led to what even the district court judge who would rule against Solomon called his prolonged, and potentially indefinite, detention. Solomon has protested with hunger strikes before, including more than a month without food while detained in an INS facility in Batavia, New York, in 1999. He was soon moved to the Columbia Care Center, a private hospital run by Just Care in South Carolina to hold federal prisoners. Then he was transferred to Etowah County. He began a new hunger strike there, and was moved to Columbia again. INS officials tried to win a force-feed order from a district court in South Carolina, and when a judge ruled against the agency, it moved Solomon back to Alabama, where a previous force-feed order was still in effect. On one occasion late last year, Solomon resisted by biting through the force-feed tube. Then jail officials forcibly sedated him. Because the medication caused him to sleep for some 13 hours, complains Solomon, he was unable to comply with the Muslim tradition of praying 5 times each day. Another time, a jail guard pulled him off his prayer mat without warning, Solomon alleges, disrespect Ramadan. He adds, however, that officials performed subsequent force feedings at night in order to respect Ramadan, during which Muslims fast during the day. After he challenged the force-feeding order in federal court in December 2000, Solomon agreed to allow officials to feed him Ensure, a nutritional supplement, until the judge ruled. Meanwhile, high-level INS officials had gotten involved. In the internal newsletter of the INS's Office for Immigration Litigation, an article about strategies for litigating such force-feeding cases had focused on Solomon. According to its author, oil attorney Paul Kovac, that article was prompted by the increasing number of cases involving detained aliens who conduct hunger strikes. Many of these cases involve the post-order detainees. Spread around the country, these protests have left INS officials and assistant United States attorneys scrambling for the appropriate response. Kovac continues, detention officials are confronted with a dilemma: do they respect the alien's choice to starve to death, or do they abide with their obligation to render medical treatment and prevent suicide by starvation? On February 15, 2001, Judge Linwood Smith of the Northern District of Alabama, ruled that the INS has legitimate peniological interests in force-feeding Nabil Solomon. Smith wrote that Solomon has been an onerous administrative burden, and also that the Chief of Corrections at Etowah County Jail overheard that other INS detainees plan to engage in a mass hunger strike if Solomon wins his case. In an interview in mid-February, while awaiting the judge's decision, Solomon said that the hunger strike is only for myself. He noted that since he is being held in the high-security unit, he has no contact with the other INS detainees. The government was thus successful in obtaining what might be called double deference from the court. First, the court should be asked to grant substantial deference to the decisions of prison administrators, Kovac suggested. Second, arguments in the immigration context are further strengthened by the deference courts afford to the executive branch in the area of immigration law. Kovac adds, somewhat ominously for the innumerable INS detainees who have been complaining in detail of the harsh conditions under which they are held, an alien's status in this country may also dictate the degree of constitutional protections he or she may be afforded. Perhaps some of these same constitutional principles can be applied to aliens challenging their treatment while in INS detention. At this writing, Solomon remains in the high-security unit of the Etowah County Detention Center. He is brought to the infirmary each day for oral gastric force feeding, according to Chief Williamson. Solomon has filed a pro se, handwritten appeal of the district court order affirming his detention and force-feeding to the 11th Circuit. In the meantime, he is demanding that he not be handcuffed and shackled each day when taken to the clinic, and he is trying to obtain a reasonably priced phone card so that he can make calls to Egypt in an effort to continue fighting his case. Chief Williamson points out that he does not control the price of phone cards sold to the prisoners. Williamson also says that while he is sympathetic to Solomon's frustrating situation, Solomon likes to use the "don't eat" issue for anything he wants. "I can't let him hold me hostage. I am not making my detention easy for them," Solomon said in our February interview at the jail in Gadsden, before the district court had ruled on force-feeding. "I have to make it hard for them." When I asked if he might starve himself to death, he compared himself to a soldier who fights for his right and his people, saying that while it is not my intention to die, that could be the result. "This is the legal way to fight them," he says. This article was written in August 2001. Anatomy of a Whitewash. Mumia Abu Jamal. 8. Authority is never without hate. Euripides. In a decision that was as remarkable as it was predictable, the Greene County David Pollock, announced his office would take no criminal action against prison guards who were viewed on videotape, roughing up men in the restrictive housing unit of the state correctional institution located in Pennsylvania Southwest. He reportedly uttered a sentence that was to the effect that his office would not tolerate violence against prisoners. Yeah, right. For several years now, men imprisoned at Cy Green have written to the local DA's office, charging any number of violent acts against them, to no avail. Most have received no answer at all. Some were told to file institutional grievances. Others had their letters Xeroxed and forwarded to Green prison officers, virtually ensuring a negative and vengeful retaliation for daring to seek legal redress. And still others had their letters intercepted, opened, read, and undelivered. Vista initially announced his probe after a series of articles came out in Pittsburgh and regional newspapers detailing violence against prisoners and threats of violence against staffers at the prison who questioned, or reported on, the violence. It was a politically savvy thing to do, as it obtained broad coverage. Several videotapes were turned over, and some interviews were taken. As politics dictated the probe, so too did it dictate that no prosecution results, for to do so would be an act of political suicide. Let us look at the matter clearly. The DA found, in his politically influenced opinion, that the shoves, pushes, and intentionally violent physical contact against naked men does not constitute a crime. In the common law, for one to threaten to do another bodily harm constitutes an assault, to touch another in an offensive way constitutes a battery. These same acts, taken up a few degrees, could cross the line to terrorist threats, or official oppression, both statutory crimes. Critical legal scholar David Carey's put it aptly when he wrote, "Law is simply politics by other means." Essentially then, the DA did what politicians do every day, he counted votes. Prisoners don't vote. Guards do. The nice speech about not tolerating violence against prisoners obscures the grim and bitter truth. It has been tolerated, it is tolerated, it will be in the future. Law, in its very heart, is profoundly conservative, and as applied to men's lives works to restrain and restrict. Over a century ago, American writer Henry David Thoreau wrote disparagingly of the pro-slavery courts of justice so-called that sided with the slave owners and were merely the inspectors of a picklock and murderer's tools, to tell him whether they are in working order or not. In his Civil Disobedience he wrote, "The law will never make men free, it is men who have got to make the law free." This article was written in October 1998. Sentenced to the backwaters of Greene County, PA. Mumia Abu Jamal. 9. There's an atmosphere created by in which this kind of thing has been going on for years. The attitude is, you're in Greene County now, boy. Randy Gager, Pennsylvania Prison Society, Fayette Greene Chapter. A handcuffed man is bludgeoned and a nightstick is jammed into his mouth, knocking out a tooth. A prison guard dips his fingers into the bloody spittle and traces the letters KKK. Welcome to Greene County's State Correctional Institution at Waynesburg, southwestern Pennsylvania. The prisoner savagely beaten by Psi guards, Antonio Nogueral, brought a lawsuit against the prison in 1996. In response to Psi guards' insistence that the beating was in self-defense, attorney Rita Murillo wrote that this beating was instead a calculated, systemic and sadistic assaults, administered for the purpose of summarily punishing Mr. Nogueral for perceived insolence, to make an example of a problem inmate in order to maintain discipline. Anticipating the release of a series of articles exposing a campaign of brutality and torture at Greene, the Pennsylvania doc beat the media pack in announcing an investigation of an estimated 40 guards at the high-tech hell. The PA doc offered a selection of routinely recorded prison videotapes to the public as proof of their innocence. Not surprisingly, the incident of Nogueral's beating was not among these tapes. According to locally published reports, several former Psi Greene staffers, who questioned the beatings and false institutional misconduct filings, were ushered out of the joint and fired. Linda Welling, a former unit manager of the prison, and Bob DeBoard, a former counselor, charged they were threatened with violence for daring to question the repressive status quo. After their charges hit the airwaves, Greene's warden was demoted and transferred to a smaller, medium-security prison. According to set theory, if one determines the perimeters of a set, one can determine the outcome. The State Corrections Department, by virtually ignoring the most serious cases of brutality, has already determined the outcome of the investigation. There will be a few sacrifices, a few transfers, a few examples of departmental discipline, but nothing substantive will change, or if it changes, it will be for the worse. The prison will remain a place of approved brutality, and staffers, terrified of the loss of jobs and pensions, will see and not see, hear and not hear, and engage in the chilling crime of silent acquiescence. For Greene was, and is, a creation of the state's political will, with terrorism merely a tool of state policy. Here, judges dare not rule against the repressive status quo, for judges, too, must bow to the dictates of state policy. This article was written in September 1998. Section 7. The Bars to Prison Litigation. In recent years, non-white, poor Americans have seen the continuous stripping away of their civil liberties and other fundamental rights via various federal legislation. From the Reagan-Bush-Clinton baby Bush eras came several pieces of legislation that took direct aim at prisoners' meager rights, both at entry points to the system and post-conviction. Now the poor, drug-addicted, and swarthy-skinned of this country can expect a variety of ways to be incarcerated for a long list of nonviolent offenses, like drug crimes, longer sentences than in any other industrialized country, lifetime incarceration under three strikes legislation, indefinite detention for immigrants with no due process or even charges filed for trivial, or non-existent offenses, and few remedies against arbitrary, dangerous, or illegal imprisonment. For prisoners, sanctified constitutional concepts like due process, freedom from unjust imprisonment, the prohibition against cruel and unusual punishment, or even the most basic of human rights often do not apply, in large part because of legislation like the Prison Litigation Reform Act and the Anti-Terrorism and Effective Death Penalty Acts. The PLRA and EDPA, in combination, present a nearly impenetrable wall against prisoners' redress for violations of fundamental human rights. Under the mandates of EDPA, for example, it is not enough for a death row prisoner to be actually innocent of the crime to win a grant of habeas corpus. And the PLRA bars any federal funding from going to legal aid groups that represent prisoners on any civil matter. Without access to competent representation, the basic means of legal redress are barred to prisoners. Prisoners now scramble to learn esoteric law as they are forced to become their own counsel. Even those prison lawyers who are capable have little to work with, as avenues of redress have been entirely closed off to them by the promulgation of a spate of anti-prisoner legislation and, in many states, the elimination of prison law libraries. The following section examines the history of prison law, its progression and regression. Th. Prison Litigation 1950-2000 Hands off, hands on, gloves on. John Midgley. doi, 10.4324/9780203952627-40. Before the middle of the 20th century, there was very little federal recognition or enforcement of prisoners' rights, as courts used the so-called hands-off doctrine to ignore prison conditions. Gradually, beginning at mid-century, rising political activism coupled with increased public awareness of atrocious prison conditions and agitation by prisoners, changed judicial attitudes toward prison issues. At the same time, advocates and courts refined the legal vehicles needed to raise prisoner issues, and so some prisoner claims started to be successful. Then, in the late 1960s through the 70s, after recognition that the Eighth Amendment's cruel and unusual punishments clause applied to the states, the movement to bring the Constitution into prisons was ablaze with hope and inventiveness, as many entire prison systems were found unconstitutionally cruel. I became involved in prisoners' rights work in 1975, at a time when my colleagues and I thought that fundamental changes in prisons could be brought about through the legal system. But we were too optimistic. Starting in the mid-70s and continuing through the rest of the century, the Supreme Court and the federal circuit courts began to limit how federal district courts could intervene to remedy the ills of prison systems. As the century drew to a close, those of us fighting for the legal rights of prisoners could be both justifiably proud of many accomplishments and apprehensive about how Congress's and the courts' trimming of the gains would play out in the long run. 1. Dark Ages end, federal courts begin to take notice of prison conditions. For a very long time, federal courts refused to review claims by prisoners. In the 19th century, prisoners were commonly viewed as slaves of the state. In the early 20th century, the courts refused to deal with prison issues by creating the hands-off doctrine, which basically set forth that prison conditions were not the court's business. 2. By the 1950s, the wall of refusal erected by the hands-off doctrine started to crack. The Supreme Court had not yet held that most of the provisions of the Bill of Rights were enforceable against the states. Among the few federal constitutional rights that did apply to the states were the First Amendment and the Due Process and Equal Protection Clauses of the 14th Amendment. 3. And federal courts began, slowly, to address abuses of prisoners under these limited legal theories. 4. In the 1960s, several developments would create a platform for prisoners to raise a much broader array of claims in federal court. Heightened political activism of the time moved into the prisons, as prisoners and free people started to question what was happening behind the walls. At the same time, the civil rights movement revived use of 42 U.S.C. 1983 to vindicate federal constitutional rights in federal court. 5. In addition, the Supreme Court began to hold that many more provisions of the Bill of Rights were incorporated into the Due Process Clause of the 14th Amendment, and so were enforceable against the states. For prisoners, a crucial moment came in 1962, when the Supreme Court applied to the states the Eighth Amendment's requirement that nor cruel nor unusual punishments inflicted. 6. Although the incorporation of the Cruel and Unusual Punishments Clause came in a case in which a sentence and not a condition of imprisonment was challenged, prisoners' advocates and thoughtful judges soon grasped what this meant for punishments carried out within prisons. In 1968, Harry Blackmun wrote for the Eighth Circuit one of the leading early statements of the Eighth Amendment's application to prison life. In a challenge to the use of the strap in Arkansas, Blackmun concluded that the history of the Eighth Amendment embodies broad and idealistic concepts of dignity, civilized standards, humanity, and decency. 7. Application of these principles led to his conclusion that use of the strap in the penitentiaries of Arkansas is punishment which, in this last third of the 20th century, runs afoul of the Eighth Amendment. The strap's use, irrespective of any precautionary conditions which may be imposed, offends contemporary concepts of decency and human dignity and precepts of civilization which we profess to possess, and, it also violates, standards of good conscience and fundamental fairness. 8. At the same time, during 1968 to 1971, prison riots broke out all over the country, dramatically increasing public awareness of the horrors inside many prisons. The most dramatic and famous was, of course, New York's Attica Rebellion in September 1971. Prisoners at Attica rebelled against a multitude of poor conditions, including rampant and widespread brutality by guards, irrational limits of 1 shower per week and 1 roll of toilet paper every 8 weeks, and prison staff's refusal to allow the rising number of African Americans who converted to Islam to practice their religion. 1,300 of the 2,000 prisoners at Attica participated in the rebellion, which began as a strike and eventually ended in prisoners holding 50 guards and civilians hostage. The rebellion ended, after many attempts at negotiation, in a bloody retaking of the yard by state officials. 29 prisoners and 10 hostages died, and many were wounded. The state initially claimed that prisoners had slit the hostages' throats, but it was later revealed that they had been killed by the gunfire of the troops retaking the yard. 9. Prison riots, like the urban riots of the same time, placed the otherwise obscure experience of prison directly under a national media spotlight. The resulting public outcry over such graphic examples of overt abuse by both state actors and prison staff forced a change that would wind its way, eventually, into the courts. A new era, successful challenges to entire prison systems. In the early 1970s, federal court scrutiny of prison conditions exploded, as prisoners and their advocates claimed that entire prison systems were cruel and unusual. In many cases, often beginning with pro-SE complaints, federal courts declared that whole jails and prisons, and even whole state prison systems, inflicted cruel and unusual punishment that is forbidden under the Eighth Amendment. Some of the leading early cases came out of the truly horrible conditions in the prisons of the southeastern United States. 10 But brutal conditions and broad reforms were the norm in other parts of the country as well, including New England. 11. In these cases and many others that followed, federal courts looked at the overall conditions in the prisons and often declared that an entire system failed to provide adequate medical care, protection from harm, and other needed services, and therefore imposed unconstitutional punishment. 12 In case after case, the federal district courts appointed special masters, or court monitors to oversee implementation of detailed orders requiring massive changes in the way prisons did business. Perhaps the peak of this kind of federal involvement in an entire prison system came when Judge Justice in the Southern District of Texas ruled that the huge Texas prison system was riddled with unconstitutional conditions throughout, and did so under the totality standard. Many courts confronted by prison cases have determined the issues, not by looking at each individual area of prison life separately, but by viewing them collectively and deciding whether the totality of prison conditions is such as to violate the Constitution. The ambient circumstances affecting inmates, considered as a whole, were found unconstitutional in. Based on a review of the exhaustive evidence and the applicable law, separate constitutional violations have been found in the areas of overcrowding, security and supervision, health care delivery, discipline, and access to the courts at TDC. Basically, these violations exist independently of each other, although the harms caused by each have been exacerbated by the others. However, even if the conditions in any one of these areas were considered not sufficiently egregious to constitute an independent violation, their aggregate effects upon TDC inmates undeniably contravene the Constitution. The grave consequences of rampant overcrowding, inadequate security, substandard health care, inappropriate disciplinary practices, and substantially impeded access to the courts manifestly dictate this result. 13. Undergirding many of the challenges to entire state prison systems was a vision and the hope that the brutal way of imprisonment being used, the very nature of imprisonment as many of these states practiced it, could itself be made humane. A few federal district courts, who took seriously that the Eighth Amendment embodies broad and idealistic concepts of humanity, required major changes, for example going so far as to order the establishment of rehabilitative and work programs where there was little for prisoners to do. 14 Some adopted an Eighth Amendment theory that any prison that threatens prisoners with deterioration due to lack of opportunities for betterment is unconstitutional. The basic import of these cases is that prison authorities have a duty to provide sufficient time, opportunities, and encouragement to overcome the degenerative aspects of the prison in question so that at least the state takes no part in the promotion of future crime. Point 15. My own early experiences were with the Washington State Penitentiary in Walla Walla, Washington. I first encountered the prison in late 1975 and conditions there were a bizarre mix. The prison was then known for being very open, with many prisoners milling around in a huge recreation area called the Big Yard. Some prisoner clubs were even given their own spaces that guards usually did not enter. Although this gave many prisoners, especially those running the clubs, some freedoms not enjoyed in other prisons, this arrangement often placed vulnerable prisoners in jeopardy. There were many deaths and injuries of prisoners and guards in this largely uncontrolled environment. At the same time, health and safety conditions were atrocious. Prisoners held in administrative segregation, sometimes for many months or even years, were not allowed outdoor exercise. Some guards routinely brutalized prisoners. Medical care was awful, and guards often decided whether prisoners should be allowed to go to the medical unit. Mental health treatment, however, was the strangest of all the programs at Walla Walla. A psychologist named Dr. Hunter ran a mental health unit on the third floor of the prison hospital. Prisoners feared being sent to the third floor, and for good reason. Many prisoners reported that the floor was run by inmate attendants who were allowed to assault other prisoners, and perhaps even to administer psychotropic medication. Program staff verbally assaulted prisoners and intentionally confiscated mattresses and blankets and used other means as well to deprive them of sleep. At the helm was Dr. Hunter, who devised a kind of aversion therapy based on performing deliberate acts of humiliation upon non-compliant or problem prisoners, including putting some prisoners in diapers and trying to humiliate gay prisoners into becoming straight. Dr. Hunter's program was eventually closed, but only after the prison was sued several times. Finally, in 1977, a state court judge held that the program violated the constitutional rights of the prisoners subjected to such therapy. A federal district court and the Ninth Circuit later found that many other conditions at Walla Walla, including medical care, segregation, and guard brutality, were unconstitutionally cruel. Point 16. Although it is hard to imagine now, in the heady days of these early victories many people thought that the federal courts would be the catalyst for a major change of not just a few awful conditions of confinement, but of an entire way of confinement. Point 17. But it was not to be. New legal hurdles erected, the Supreme Court jumps in. The federal judiciary became more conservative beginning in about 1969. 181 result was that some of the federal courts of appeals began to trim the most ambitious of the federal district courts' attempts to reform prisons. The appeals courts found that while awful medical care and gross lack of safety may be remedied through constitutional litigation, other important components of prison life such as a lack of rehabilitative programs and even prisoner classification systems were not of constitutional concern. 19 Under particular attack in some federal circuits was the totality of the circumstances test used to find entire prisons or systems unconstitutional in some jurisdictions. The Ninth Circuit strongly disapproved of the totality standard and reversed district court opinions employing the standard. 20 Many of these same decisions also started to place stricter limits on what forms of relief could be ordered to remedy constitutional violations. These developments provide the background for the Supreme Court's involvement in the development of the law of prisoners' constitutional rights. The court had decided only a few scattered prisoners' rights cases over the years. But starting in the mid-1970s, the court became very active and, while making clear that the Constitution does reach into state prisons, also began to set limits on what federal courts could do to remedy bad prison conditions. First, the Supreme Court made clear that the hands-off doctrine was long dead. Though some state officials continued to insist that federal courts should leave the issue of prisoners' constitutional rights alone, the court emphatically disagreed in the early 1970s. To underscore this recognition of prisoners' claims, the court pointed to areas where prisoners' constitutional rights had already been articulated in the law. 21. But to say, as the Supreme Court did, that the Constitution has some reach behind prison walls does not answer exactly what constitutional rights prisoners have in specific situations. And the increasingly conservative court, with a few exceptions, has acted to limit prisoners' rights in many important ways. This is shown in the following, which is a brief survey of Supreme Court developments in 4 selected areas of the law of prisoners' rights that are analytically distinct: general prison conditions and practices, procedural due process, personal rights, and access to courts, conditions of confinement, and the state of mind requirement. The Supreme Court's first venture into conditions issues involved a claim by one prisoner that he was denied necessary medical care and that this was a violation of the Eighth Amendment. Estelle v. Gamble, 429 U.S. 97. Justice Marshall, in writing for the court majority, affirmed the general Eighth Amendment analysis that many of the lower federal courts had been applying to conditions issues, embodying broad and idealistic concepts of dignity, civilized standards, humanity, and decency, and the evolving standards of decency that mark the progress of a maturing society. The court, however, also decided that while the Eighth Amendment requires prison officials to provide medical attention for those they incarcerate, not every failure to provide adequate care would be a constitutional violation. The court therefore articulated a standard that prisoners must meet in order to state a claim for the unconstitutional denial of medical care. A prisoner must show that defendant prison officials demonstrated deliberate indifference to serious medical needs. 22. This has proven a difficult standard to meet, and most medical abuse cases fail because of it. In the lone dissenting opinion in Estelle, Justice Stevens prophetically questioned the newly coined deliberate indifference standard, noting that it focused on the defendant's state of mind instead of the impact on the prisoner. Whether the constitutional standard has been violated should turn on the character of the punishment rather than the motivation of the individual who inflicted it. Whether the conditions in Andersonville were the product of design, negligence, or mere poverty, they were cruel and inhuman. 23. In 1978, the Supreme Court first reviewed one of the class action cases in which a federal district judge was trying to reform a truly awful prison regime. 24. The Arkansas prison system was described as a dark and evil world alien to the free world, in which the court noted that supervision at night in the large barracks was so lax that some prisoners dared not sleep. Instead, they would leave their beds and spend the night clinging to the bars nearest the guard station. Other prisoners were out in punitive isolation, where an average of 4, and sometimes as many as 10 or 11 prisoners were crowded into windowless 8x10 cells and were fed fewer than 1,000 calories a day in the form of a thing called gruel. In the Arkansas system, it was also routine to arm prisoners with guns, and employ them as guards. And prisoners were frequently whipped with a wooden-handled leather strap 5 feet long and 4 inches wide. 25. The court was asked to decide whether the district court properly limited stays in disciplinary isolation to 30 days. The court found that although the Eighth Amendment did not, in the abstract, require a limit of 30 days in isolation, given the horrors that had been proven about isolation, the district judge was within his powers to impose this limit. 26. A few years later, the court took up the legal standard to be applied in deciding whether prison conditions were bad enough to be cruel and unusual. Perhaps unfortunately, this consideration came in a case where prison conditions were not nearly as bad as the conditions in the nightmare that prevailed in Arkansas. In Rhodes v. Chapman, 452 U.S. 337, 346 to 347, prisoners in a relatively new Ohio prison claimed that forcing 2 people to live in a 63-square-foot cell designed for only one violated the Eighth Amendment. The court held, as it had earlier in a jail case that involved a slightly different constitutional standard. 27. That the Constitution, through the Eighth Amendment, does not require a certain amount of living space for a prisoner or mandate only one prisoner per cell, even a small cell designed to house only one person. The court did make passing reference to idealism and the evolving standards of decency that mark the progress of a maturing society, but nevertheless declared that the Eighth Amendment is violated only if conditions amount to at least one of the following: the wanton and unnecessary infliction of pain, pain without any penological purpose, serious deprivation of basic human needs, or deprivation of the minimal civilized measure of life's necessities. 28. In defining these standards, the court also gave lower courts a contradictory set of instructions that makes it harder for prisoners to prevail in Eighth Amendment cases. The court said that whether conditions are cruel must be determined objectively, but also said that the lower courts could not use expert opinions and published professional standards to determine constitutional minimums for prisoner living conditions. 29. In lieu of using published standards, Rhodes says that federal judges should, in making Eighth Amendment judgments, decide whether a prison condition is viewed generally as violating decency. 30. Thus the court took from prisoners a powerful, objective measure of what is reasonable treatment and replaced it with an obviously quite subjective inquiry into general views of decent standards for prisoners. The Supreme Court thus set difficult standards for prisoners to meet before a federal court could declare conditions unconstitutional, but nevertheless prison litigation continued all over the country. However, federal courts found that conditions in plenty of jails and prisons were poor enough even to meet the new standard. 31. In 1986, the court again considered whether a prisoner claiming an Eighth Amendment violation must in some cases show that a defendant has a particular state of mind. In a case in which a guard wielding a shotgun had shot a prisoner in connection with a prison disturbance, the court held 5-4 that there could be no Eighth Amendment violation in the shooting unless the prisoner could demonstrate a very difficult-to-prove state of mind, that is, that the guard acted maliciously and sadistically for the very purpose of causing harm. 32. In a major development 5 years later, the court held that there is a state of mind element in all claims that the Eighth Amendment has been violated, even claims made by large groups of prisoners that conditions of confinement for all of them are unconstitutional. In Wilson v. Sider, 501 U.S. 294, the court held 5-4 that bad conditions alone are never enough to make out an Eighth Amendment violation. Instead, in addition to an objective component, all Eighth Amendment claims also have a subjective component. The court then said that for most claims, individuals or groups of prisoners claiming that conditions of confinement violate the Eighth Amendment must prove that the defendant acted with deliberate indifference to the bad conditions. The deliberate indifference standard had of course been coined in Estelle v. Gamble as a way to determine whether a single prisoner's complaint about medical care amounted to more than an accusation of ordinary medical negligence. The dissent in Wilson echoed the original lone dissent of Justice Stevens in Estelle, pointing out that the Eighth Amendment focus should be on the unnecessary pain inflicted by bad conditions, and that what is in the mind of the prison officials is irrelevant to whether those conditions are cruel and unusual. But the Wilson majority ignored this and extended the deliberate indifference standard far beyond its original purpose, to a requirement that all prisoners claiming an Eighth Amendment violation show not only how bad living conditions are but also that prison officials ignored the conditions. Wilson also addressed the still lingering totality of conditions question: can a combination of several bad conditions not each unconstitutional in itself add up to an Eighth Amendment violation? In Rhodes, the court had said that conditions, alone or in combination, could be cruel and unusual punishment. 33 But Wilson read in combination very narrowly and said that the Eighth Amendment can be violated only in terms of discrete conditions that must be analyzed separately. Some conditions of confinement may establish an Eighth Amendment violation in combination when each would not do so alone, but only when they have a mutually enforcing effect that produces the deprivation of a single, identifiable human need such as food, warmth, or exercise. For example, a low cell temperature at night combined with a failure to issue blankets. Nothing so amorphous as overall conditions can rise to the level of cruel and unusual punishment when no specific deprivation of a single human need exists. 34. Wilson signaled the court majority's abandonment of the broad and idealistic concepts of dignity, civilized standards, humanity, and decency that had animated Eighth Amendment analysis of prison conditions since Harry Blackman's groundbreaking analysis for the Eighth Circuit in 1968. Instead of invoking these important ideals of our civilization that could spark real change in prisons, Wilson requires a much narrower focus. Federal courts should look at one distinct prison condition at a time, and may intervene only if the condition is a severe deprivation of basic human needs that prison officials have deliberately left to fester. Details filled in. The Supreme Court's later prison conditions cases in the 1990s elaborated upon the objective and subjective components of Eighth Amendment doctrine. In the most significant case on this issue, the court held that when a prisoner makes any claims that a guard used excessive force, the prisoner must prove that the guard acted maliciously and sadistically for the very purpose of causing harm. 35. However, the court also said prisoners claiming excessive force do not have to also show that they received a serious injury. The court said it would be enough to show that there was an unnecessary infliction of pain and the defendant acted maliciously and sadistically. The court also affirmed for the first time a principle of Eighth Amendment law that many lower courts had been applying for some time, that prisoners may obtain an injunction against a condition that poses an unreasonable risk of harm to prisoners before the likely harm occurs. 36. The court's final major foray in prison law in the 1990s addressed the meaning of the strange legal phrase deliberate indifference, which had become the crucial issue in many cases. Most everyone agreed that deliberate indifference must be more than negligence, but less than the malicious and sadistic standard that the court applied to officials' use of force on prisoners. The available mental states between these two poles are so-called civil recklessness and criminal recklessness. In Farmer v. Brennan, 511 U.S. 825, the court adopted the criminal recklessness standard and held that to be deliberately indifferent, a prison official must know of a substantial risk of serious harm and fail to remedy it. 37. The deliberate indifference requirement of Eighth Amendment analysis has not served as a complete barrier to federal court intervention where prison conditions are poor enough and the harm to prisoners is obvious. But the deliberate indifference requirement poses an unnecessary hurdle in many cases, where very bad conditions or obviously unnecessary inflict ions of pain should be plenty for a prisoner to show that the Eighth Amendment's prohibition against cruel and unusual punishment has been violated. Procedural due process. The Due Process Clause of the 14th Amendment prohibits states from depriving any person of life, liberty, or property, without due process of law. Thus, if the state proposes to take a citizen's liberty or property, the state must do so by process of law. Prisoners often claim that the state is taking their liberty or property without legal justification. In order to claim that the state is unconstitutionally taking liberty without due process, a prisoner must first establish that there is a liberty interest that is protected against arbitrary state action. Liberty interests that are subject to due process can come from two sources: directly from the idea of physical liberty that is inherent in the Due Process Clause itself, or from state-created liberty interests. A state creates a liberty interest when it makes a rule that it cannot do something to a citizen unless certain things are proven, for example that prison officials cannot take a prisoner's good time sentence reductions away unless the prisoner is proven to have misbehaved. 38 With respect to prisoners, the court has found inherent liberty in very few instances, and usually requires prisoners to show a state-created liberty interest. And recently the court erected barriers to prisoners' due process claims, even where there are state-created liberty interests. Wolf v. McDonnell, 418 U.S. 539, a state-created liberty interest case, brought procedural due process into prisons. In Wolf, Nebraska prisoners were entitled by law to good time sentence reductions unless the state proved a prisoner had engaged in serious misconduct. The court found that the state-created good time entitlement triggered federal procedural due process protections. The court held that the process due was advance notice of specific charges, a hearing at which the prisoner had the right to testify and present witnesses and evidence, and a statement of evidence and reasons for any finding of guilt. In inherent liberty cases, by contrast, the court has found that prisoners have inherent liberty protected by the Due Process Clause in matters that are significantly outside the bounds of the criminal sentence that has been imposed on the prisoner. For example, prisoners are protected by the Due Process Clause against involuntary transfer to a mental hospital, or involuntary administration of psychotropic drugs without procedural due process, because these deprivations of physical and mental liberty are not generally seen as within the bounds of a prison sentence. 39. but within what the Supreme Court majority has seen as the broad bounds of the sentence imposed, the court has refused to find inherent physical liberty. In Meacham v. Fano, 427 U.S. 215, the court majority refused to find inherent liberty implicated in transfer from one prison to a more restrictive one, because transfer to another prison was within the normal limits or range of custody which the conviction has authorized the state to impose. 40. Justice Stevens, writing for 3 dissenters, foresaw, just as he had at the birth of the deliberate indifference standard, the constitutional mischief that the court's new analysis would create. If the inmate's protected liberty interests are no greater than the state chooses to allow, he is really little more than the slave described in the 19th century cases. I think it clear that even the inmate retains an unalienable interest in liberty, at the very minimum the right to be treated with dignity, which the Constitution may never ignore. 41. Stevens' worst fears were realized when the court later held that a prisoner in Hawaii had no inherent liberty interest to prevent a transfer to a prison thousands of miles away on the mainland. 42. The court majority, quoting Meacham, found that confinement in another state, unlike confinement in a mental institution, is within the normal limits or range of custody which the conviction has authorized the state to impose. The court consistently refused to find that federal due process was involved in prison operations unless there was a state-created liberty interest in the form of facts the state had to prove under its own laws or regulations before it could impose discipline or more restrictive conditions. The court held that prospective parolees had no federal constitutional right to a parole hearing in the absence of a state-created liberty interest. 43. Similarly, when state prison regulations allowed placement of a prisoner in administrative segregation only if the state could prove certain facts, the court found a state-created liberty interest and required procedures. 44. Then the court completely changed the state-created liberty interest analysis to make it even harder for prisoners to invoke the protections of procedural due process. In Sandin v. Connor, 515 U.S. 472, the court held that liberty interests for federal due process purposes can be created only when the state imposes an atypical and significant hardship compared to what the court views as the ordinary incidents of prison life. In Sandin, 30 days of disciplinary segregation was held not to present such a hardship, and so due process protections did not apply to the procedure that resulted in the segregation, even though the state regulations did stipulate that there would be no disciplinary segregation unless the state could prove that the prisoner had committed particular acts. 45. Under long-standing due process analysis, either a grievous loss or a state-created liberty interest would suffice to invoke due process protections. After Sandin, it now appears that in order to invoke procedural protections of the Due Process Clause, prisoners must show both that the state has bound itself to prove certain facts before taking action, and that there is an atypical and significant hardship as to actions by the state that do not relate to the length of incarceration. 46. Personal Rights First, Fourth, and 14th Amendments. The Supreme Court's entry into the area of personal rights retained by prisoners started off fairly well for prisoners. The court held early on that overt racial discrimination and segregation is unconstitutional. 47. The court also found that a Buddhist prisoner who was not afforded the same right to worship as members of other religions stated a violation of his equal protection rights. 48. And in a very significant case, Procunior v. Martinez, the court held that while prison officials could censor prisoners' mail in some circumstances, the First Amendment required that they only censor mail to the extent that they could show that the regulation further an important or substantial governmental interest unrelated to the suppression of expression and is no greater than is necessary or essential to the protection of the particular governmental interest involved. 49. Using this test, the court invalidated California's mail censorship regulations because they allowed censorship of criticism of prison conditions and management. However, as the court became more conservative, some of these early openings were soon isolated and then reversed. In Jones v. North Carolina Prisoners Labor Union Incorporated, 433 U.S. 119, the court endorsed a state prison system's ban on meetings of a prisoners' labor union formed to improve working and living conditions for prisoners, and also allowed prison officials to prohibit prisoners from asking each other to join the union, and from using bulk mailings on union business. In dissent, Justices Marshall and Brennan strongly disagreed with the court's extreme deference to the preferences of prison administrators who clearly intended to suppress prisoners' organizations. 50. Jones is a crucially important case in the development of the rights of prisoners. The majority determined that rather than prison administration having to show good reasons for its drastic restrictions, the prisoner must show that there is no plausible basis. Prison officials concluded that the presence, perhaps even the objectives, of a prisoner's labor union would be detrimental to order and security in the prisons. It is enough to say that they have not been conclusively shown to be wrong in this view. 51. Thus the court laid the theoretical groundwork for a new hands-off doctrine in the area of personal rights. After Jones, the court increasingly restricted prisoners' intellectual freedoms. In Bell v. Wolfish, the case involving the rights of pretrial detainees who have not yet been convicted, the court relied heavily on Jones to hold that detainees could not receive books except from publishers, book clubs, and bookstores, and could not receive any packages from outside. Then, several years later, in Turner v. Safley and its progeny, the court explicitly overruled the pecuniary test requiring a substantial relationship to a legitimate governmental interest, and replaced it with a standard that is exceedingly deferential to those who run the prisons. Any regulation that a court finds reasonably related to legitimate penological objectives will be upheld. 52 Crucially, the burden is now on the prisoner to show that the regulation is irrational rather than being on the prison administration to show why the regulation is reasonable. This changes the result in many cases. For example, the Supreme Court upheld a prison rule that prohibited Muslim prisoners from attending their Sacred Friday service, and did so without requiring the prison to show that there were not other ways in which legitimate security interests could be accommodated while still allowing the Muslims to worship on their holy day. 53. Prisoners have never fared well in the Supreme Court regarding Fourth Amendment rights against unreasonable searches and invasions of privacy. Prisoners have no right of privacy in their cells, which are completely subject to search. 54 Personal privacy is very limited. The court has even allowed pretrial detainees to be strip-searched without probable cause. 55. The court has relented slightly in areas involving family and the right to association with people outside prison. The court has held that prisoners are entitled to some visitation, at least with family members, but not contact visitation. 56 And the Supreme Court has found that prisoners retain the right to marry subject to relatively minimal restriction by prison authorities. 57. Access to courts is a crucial issue for prisoners. After Jones v. North Carolina Prisoners Union, prisoners have no right to organize, or even to assemble to speak on subjects of clear public and political concern, rights upon which the rest of us rely in making our voices heard on important public policy questions. This enforced powerlessness necessarily increases prisoners' reliance on the courts to address awful conditions and other terrible problems. In light of Jones, and the ability of the political system to completely ignore prisoners' reliance on the courts is not excessive, it is necessary, since courts are the only powerful institution that must at least consider prisoners' petitions for redress of grievances. Court is naturally where prisoners go to seek relief. Even before the modern era of prisoners' rights litigation, the Supreme Court recognized the right of prisoners' access to the courts, at least to file habeas corpus petitions challenging whether they should be imprisoned at all, and held that prison officials cannot obstruct exercise of this right. 58 And after courts began to hear cases regarding conditions inside prisons, the court extended the right of access to include the filing of complaints regarding conditions. 59 It was understood that prisoners are entitled to unobstructed and confidential communications with courts, attorneys, and their assistants. 60. Beginning in the 1970s, prisoners began to assert that in order to put flesh on the right of access, they needed tools to help them put together court papers. In 1977 the Supreme Court seemed to agree, suggesting that in order to make real the right of access, prisoners are entitled either to adequate law library facilities or persons trained in law to help them exercise that right. 61 After this ruling, law libraries were established in many prisons throughout the country, and for many years there was litigation regarding the adequacy of systems of providing either law libraries or legal assistance. However, in Lewis v. Casey, 518 U.S. 343, the court clarified its earlier pronouncements, holding that this constitutional right of access encompasses less than the provision of tools so that prisoners may adequately litigate cases. Instead, the court found that the right of access is merely the ability to file adequate initial papers in criminal appeals, conditions, and habeas cases, and that prisoners cannot sue for denial of access just because the prison law library is allegedly inadequate, but rather must show actual injury. To be entitled to relief, a prisoner must show that the alleged shortcomings hindered his efforts to pursue a legal claim. 518 U.S. at 351. Casey involved prison officials' affirmative obligation to provide access to the courts, and it certainly raises questions about whether something other than full law libraries will suffice to meet constitutional requirements. However, Casey did not disturb the early cases holding that prison officials cannot interfere with access to courts and counsel. Full backlash by the end of the century. By the century's end, Congress weighed in with a series of measures designed to limit prisoners' access to the courts, access that had for 30 years provided at least a measure of relief from the worst prison conditions. As is detailed in the following chapter of the present book, through the Prison Litigation Reform Act and the Anti-Terrorism and Effective Death Penalty Act, Congress sought to limit when and how prisoners could seek court redress, how much and for how long federal courts can be involved in trying to eradicate bad conditions, and even how much prisoners' lawyers can be compensated by the perpetrators of the conditions being remedied. 62 In another blow to prisoner access, especially those in local jails, Congress also prohibited any lawyers receiving federal civil legal services funds for poor people from representing any prisoner on any matter. 63. The Supreme Court majority, as chronicled above, also had done its part by century's end. While giving lip service to the continued existence of constitutional rights, the court limited as much as possible the day-to-day realization of the rights prisoners supposedly retain. Personal rights, especially under the First Amendment, were scuttled in the late 80s with the rise of the extremely deferential Turner v. Safley doctrine. In the 90s, more damage was done. The Scalia opinions in Wilson v. Sider and Lewis v. Casey, along with the Rehnquist opinion in Sandin v. Connor, all make it much harder for prisoners to obtain relief from oppressive conditions and practices. Qualified success: what has been accomplished, what has not. Viewed in historical perspective, prison litigation has accomplished much. The very idea that people in prisons have basic, enforceable human rights has become accepted at a level that could not have been anticipated even 50 years ago. For example, today the United States Supreme Court, as destructive as it has been to the rights of ordinary people, takes as a given that the United States Constitution stipulates that certain basic human rights are to be provided to people the state holds in institutions. 64 Because of this recognition of constitutional protection for prisoners, many of the very worst conditions that prevailed in prisons throughout the country into the 1970s have been eradicated. This is not enough or where it should end, but it is a great victory. In addition, prison litigation has been a major catalyst in the incredible increase in at least the expectation of professionalism in two areas: medical care and personal safety of prisoners. When I started doing prison law in 1975 at the Washington State Penitentiary in Walla Walla, the medical staff consisted mostly of men who had been medics in the military. These unlicensed people were prescribing medications and were virtually unsupervised. There were no serious standards or procedures by which the medical staff was governed, no official expectation that custody staff must report medical complaints to the medical department rather than conduct on the THIRD diagnosis themselves. Medical care in prisons today is far from ideal, but there now are standards, expectations, licensure, and training, and even professional organizations dedicated to adequate care for prisoners. These developments, if they had happened at all, would have been much slower without the many federal cases condemning inadequate care and staffing in prisons and jails across the country. Similarly, largely as an outgrowth of cases such as Jackson v. Bishop, 404 F.2d 571, Holt v. Sarver, 309 F.Sup. 362, and Woodhouse v. Virginia, 487 F.2d 889 and their progeny, the official expectation that prisoners should not be abused has become the norm. This has resulted in higher standards of conduct for guards, better training, and closer supervision of prisoners for protection. I do not suggest that bad prison medical care and brutality against prisoners has been eliminated. Obviously, they have not. But I also believe that this litigation-spurred establishment of professional standards and expectations has saved the life and limb of many prisoners who would otherwise have been brutalized. But there is also much to be unhappy about. As the discussion above shows, the true essence of the constitutional provisions prisoners invoke is human dignity, and a crucial focus on this has been lost. The early cases focused on this core value and so naturally looked at the conditions of incarceration as a whole. But the Supreme Court has turned away from these higher values and what they imply for the way we treat prisoners, and has delivered a most destructive blow in the area of conditions by requiring that conditions must be looked at in a discrete, disconnected way, in effect, requiring that only one condition at a time may be viewed and determined to be either constitutional or not. 65. One fairly recent case illustrates this approach. In Madrid v. Gomez, 889 F.Sup. 1146, a conscientious federal judge looked at the horrific conditions and practices at the infamous Pelican Bay Supermax prison in California. The judge found that there was a practice of permitting and condoning a pattern of excessive force by subordinates, as reflected by defendants' management of the prison over an extended period of time. This pattern consisted of assaults, beatings, and naked cagings in inclement weather. 66. In addition, as to medical and mental health care, conditions were objectively awful and the defendants had exhibited deliberate indifference. Therefore, the court had little trouble finding Eighth Amendment violations and issued an injunction against these practices. But on the subject of whether the confinement in the security housing unit at Pelican Bay was, in and of itself, cruel and unusual punishment, this conscientious judge found his hands tied. The judge noted that prevailing Eighth Amendment law is that while some degeneration of prisoners in certain conditions is not necessarily a constitutional violation, evidence that serious deterioration is caused by certain conditions might be a violation. The court then said, what plaintiffs object to is not merely an absence of programs, but a more universal deprivation of human contact and stimulation, including the stark physical environment, the lack of any window to the outside world, the geographically remote location of Pelican Bay, and the extreme degree of social isolation. Of these conditions appear, at best, tenuously related to legitimate concerns. Conditions of extreme social isolation and reduced environmental stimulation will likely inflict some degree of psychological trauma upon most inmates confined there for more than brief periods. However, for many inmates, it does not appear that the degree of mental injury suffered significantly exceeds the kind of generalized psychological pain that courts have found compatible with Eighth Amendment standards. 67. The judge in Madrid then found that the SHU was unconstitutional housing only for people who already had serious mental health issues, as putting them in SHU is the mental equivalent of putting an asthmatic in a place with little air to breathe. 68. But for other prisoners, housing in this same place was not unconstitutional. It is sad, indeed, that Eighth Amendment law now apparently allows prison officials to place an asthmatic in a place with little air to breathe, or, more to the point, put a sane person in a place that necessarily makes people prone to insanity more insane. Eighth Amendment analysis for prisons started with the ideals of basic decency and humanity. It has surely strayed from these ideals if it permits this kind of obviously inhumane incarceration. Finally, while courts must look at bad physical conditions and medical care, or the very worst of them anyway, the spiritual and political rights of prisoners are very severely restricted, and under the prevailing Turner standard of extreme deference to authority, there is often little prisoners can do about this. Something very close to hands-off prevails in areas of rights that free people take for granted: privacy, speech, assembly, exercise of religion. Even if prisoners must have more restrictions on these rights than free people, many of the restrictions that the federal courts have allowed in the name of holy deference are not necessary. The people we incarcerate can be killed in spirit even if we keep their bodies alive. The federal courts are not powerless to address crucial issues of the spirit for prisoners. Much of the Bill of Rights addresses exactly these vital matters. Perhaps someday the courts will begin to grant prisoners a greater measure of these important rights. Notes: because of space limitations, what follows is an extremely condensed overview of the large body of federal constitutional prison law over the period I discuss. See Mushlin, Rights of Prisoners, Volume 1 at 7-9. Gitlow v. New York, 268 U.S. 652. The 14th Amendment, of course, explicitly applies to the states. See, for example, McCollum v. Mayfield, 130 F.Sup. 112, 115, Sewell v. Pegelow, 291 F.2d 196. Matthew T. Clark, Barring the Federal Courthouse to Prisoners. Robinson v. California, 370 U.S. 660. Jackson v. Bishop, 404 F.2d 571, 579. ID. A good short account of the Attica Rebellion is Coghlan, Attica, The Prison Revolt of 1971, http://home.earthlink.net/-dwsgsht/attica.html. See, for example, Gates v. Collier, 501 F.2d 1291, Pugh v. Locke, 406 F.Sup. 318. Layman v. Helgmo, 437 F.Sup. 269. See the listing of cases in Justice Brennan's concurring opinion in Rhodes v. Chapman, 452 U.S. 337, 353-54. Ruiz v. Estelle, 503 F.Sup. 1265, 1383-84. E.g., Pugh, 406 F.Sup. at 335. Lahman, 437 F.Sup. at 317. Hoptowit v. Ray, 682 F.2d 1237. See Yackel, Reform and Regret, The Story of Federal Judicial Involvement in the Alabama Prison System. For 20 of the 24 years beginning on Inauguration Day in 1969 and ending Inauguration Day in 1993, Republican Presidents Nixon, Ford, Reagan, and the elder Bush were appointing all federal judges. Newman v. Alabama, 559 F.2d 283, 290-92, Hoptowit, 682 F.2d at 1253-55. Wright v. Russian, 642 F.2d 1129, Hoptowit, 682 F.2d at 1246-47. Wolf v. McDonnell, 418 U.S. 539, 555-56. 429 U.S. at 104. ID at 96-97. Hutto v. Finney, 437 U.S. 678. ID at 681-83. ID at 687. Bell v. Wolfish, 441 U.S. 520, applying a due process standard to people detained pending trial but not yet convicted. 452 U.S. at 345-47. Compare Bell, 441 U.S. at 542, for prisoners being held in lieu of bail but not yet convicted of a crime, absent a showing of intent to punish, only conditions that are not reasonably related to a legitimate governmental objective or inflict genuine privations and hardship over an extended period of time would violate the Due Process Clause. Rhodes, 452 U.S. at 346-47, citing Bell. ID at 348. E.g., Hoptowit, Fisher v. Kohler, 692 F. Sup. 1519. Whitley v. Albers, 475 U.S. 312. Rhodes, 452 U.S. at 347. 501 U.S. 304-305. Hudson v. Macmillan, 503 U.S. 1, 5-7. Helling v. McKinney, 509 U.S. 31. In practical terms, whether the defendant had actual knowledge depends upon how obvious and how long-standing the bad conditions are, and a defendant who avoids on purpose knowing the obvious may be found to be deliberately indifferent. See generally Boston et al., Farmer v. Brennan, defining deliberate indifference under the Eighth Amendment, 14 St. Louis UPUBL Revelation 83. Farmer also made clear what lower courts had assumed for many years: prisoners are protected by the Eighth Amendment against a serious and pervasive risk of harm through assault by other prisoners. Vitek v. Jones, 445 U.S. 480. Vitek, Washington v. Harper, 494 U.S. 210. Meacham, 427 U.S. at 225. 427 U.S. at 233-34. Olam v. Wakinakona, 461 U.S. 242. Greenholds v. Nebraska Inmates 442 U.S. 1, Board of Pardons v. Allen, 482 U.S. 369. Hewitt v. Helms, 459 U.S. 460. A revealing aspect of the court's transparent shifting about to avoid due process results favorable to prisoners is Chief Justice Rehnquist's sharp criticism in the Sandin majority opinion of the state-created liberty interest analysis in Hewitt v. Helms, an opinion Rehnquist also authored. Faced with the fact that Hewitt would actually provide expanded rights in some cases, the Chief Justice, with a more conservative majority in place, decided Hewitt's purpose had been served, and abandoned it as though it had been misguided from the beginning. The court in Sandin suggested that the results in both Wolf v. McDonnell and Board of Pardons v. Allen did still demonstrate a liberty interest sufficient to invoke the Due Process Clause. Both of those cases involved length of incarceration issues. Lee v. Washington, 390 U.S. 333. Cruz v. Beto, 405 U.S. 319. Percunior v. Martinez, 416 U.S. 396, 413. 433 U.S. at 139-147. 433 U.S. at 132. Turner v. Safley, 482 U.S. 78, Olone v. Estate of Shabazz, 482 U.S. 342, Thornburg v. Abbott, 490 U.S. 401. Olone v. Estate of Shabazz. Hudson v. Palmer, 468 U.S. 517. Bell v. Wolfish, 441 US at 558 to 560. Block V. Rutherford, 468 US 576. Turner v. Safley. X Part Hull, 312 US 546. Wolf v. McDonnell. Percunior v. Martinez, 416 US 396, 419. Bounds v. Smith, 430 US 817. Matthew T. Clark, barring the federal courthouse to prisoners. See 45 Code of Federal Regulations, Section 1637. Thus Chief Justice Rehnquist, no friend of prisoners' rights, can write matter-of-factly in an opinion he penned for the court that the state by the affirmative exercise of its power so restrains an individual's liberty that it renders him unable to care for himself, and at the same time fails to provide for his basic human needs, e.g., food, clothing, shelter, medical care, and reasonable safety. It transgresses the substantive limits on state action set by the Eighth Amendment and the Due Process Clause. DeShaney v. Winnebago Cty. SOC. Services Department, 489 US 189, 200. See discussion above of Rhodes v. Chapman and Wilson v. Sider. 889 F.Sup. At 1250, 1252. Madrid, 889 F.Sup. At 1264 to 65. ID at 1265. This article was written in February 2002. Barring the federal courthouses to prisoners. Matthew T. Clark. doi, 10.4324/9780203952627-41. If someone assaults you, or illegally holds you against your will, you would likely report it to the police. In theory, the police and prosecutors take over from there. If someone at work calls you by a racial slur, or sexually harasses you, you might go to the relevant civil rights enforcement agency for redress. If your landlord refuses to keep up your building, you could file a grievance with the Housing Commission. If you are injured on the job due to unsafe workplace conditions, you might head to your local workmen's compensation office, and perhaps you might hire a personal injury lawyer. But what would you do if you were a prisoner who experienced any of these conditions? Who would you turn to if the people who assaulted you, subjected you to the unsafe conditions, sexually harassed, or even raped you were the very people responsible for your safety? What would you do if your incarceration was unjust, the result of police and prosecutors willing to bend the rules to secure convictions? Until recently, there were two groups of laws that acted as the guardians of prisoners' rights, the Federal Civil Rights Laws 1983 and 1985, and the Federal Habeas Corpus Laws. The civil rights laws were the historic vehicle for a prisoner to enforce his or her right to decent prison conditions and medical treatment, and to sue for abuse suffered at the hands of prison staff. Habeas corpus laws were used by prisoners to get another day in court if illegal prosecution and police actions eclipsed justice during their criminal trial. Passage of two fairly recent pieces of legislation, the Anti-Terrorism and Effective Death Penalty Act and the Prison Litigation Reform Act of 1996, radically emasculated these historic vehicles for legal redress, and just for one class of people, prisoners. With recent amendments to these two groups of laws, it is now much more difficult for prisoners to get into court, and nearly impossible for them to win once they get there. The Civil Rights Laws and 1983. Of the civil rights statutes available, the statute most commonly utilized by prisoners in vindicating their civil rights is 42 U.S.C. 1983, generally referred to as 1983, which states the following. Every person who, under color of any statute, ordinance, regulation, custom, or usage, of any state or territory, subjects or causes to be subjected, any citizen of the United States or other persons within the jurisdiction thereof to the deprivation of any rights, privileges, or immunities secured by the Constitution and laws, shall be liable to the person injured in an action of law, suit in equity, or other proper proceedings for redress. Essentially, 1983 allows people whose civil rights have been violated to sue the people who violated them. Under 1983, the illegal action must be performed under color of state law, which limits possible defendants to government employees and those performing traditionally recognized government acts. Thus, it is one of the most useful statutes for state prisoners whose civil rights have been violated by prison employees. This primary tool was retracted for prisoners only with the passage of the PLRA. The Prison Litigation Reform Act. On April 26, 1996, President Clinton signed the Prison Litigation Reform Act into law. The express purpose of the PLRA was to impede prisoner litigation, and it has been enormously successful in this respect. Because of key provisions discussed below, prisoners now cannot secure representation for most civil rights complaints. To create an effective bar to prisoners' suits, the PLRA addressed several central aspects of such litigation, including 1. The right to file a lawsuit without prepaying filing fees, 2. The right to have attorney fees awarded upon winning the suit, 3. The requirement of exhausting all administrative remedies available prior to filing the lawsuit, and 3. The scope of relief the court may grant a prisoner. 1. Attorney fees limitations. The stereotype of prison litigation is that prisoners entertain themselves by mounting one frivolous, often ridiculous civil rights lawsuit after another. With nothing to do, they while away the hours acting as a thorn in the government's side as often as possible. Suits, like the one brought by a prisoner for slipping on a pillow, help confirm this idea of prison litigation. Capitalizing on this perception, drafters of the PLRA ensured that prisoners are now likely to be the only ones who will bring their case. The mandates of the PLRA effectively cut most prisoners' attorneys out of the field. The drafters of the PLRA separated the interests of prisoners and their attorneys significantly by changing the way attorneys' fees are awarded. Prior to the PLRA, any prevailing party in a civil rights action could be awarded attorneys' fees at the lawyer's standard billing rate, which means that the prevailing party could require the losing party to pay for the winning party's attorney. The amount awarded was then determined by the court, subject to a challenge and/or appeal if found to be unreasonable. With the enactment of the PLRA, attorneys' fees may not be awarded at an hourly rate greater than 150% of what court-appointed counsel are paid in criminal cases. 2. Another provision mandates that a total attorney fee may not exceed 150% of the final judgment. 3. For example, a First Circuit court recently interpreted this provision as such: a prisoner who prevails and wins a nominal damage award of $1 may not recover more than $1.50 in attorney's fees. 4. Additionally, the attorney fees award first comes out of up to 25% of the damage award won by the prisoners. This requirement essentially means prevailing parties must pay themselves from monies in the damages award. 5. At first blush, 150% of the court-appointed criminal defense attorney's rate may not seem so bad. However, there are three factors that make this arrangement unacceptable to most attorneys. Court-appointed criminal defense attorneys are paid whether they win or lose, whereas attorneys representing indigent prisoners in civil rights cases only get paid if they win. Also, court-appointed criminal defense attorneys are notoriously underpaid. 150% of an underpaid attorney's fee may still be only a fraction of the average fee charged by private attorneys. And private attorneys have large overhead costs. Therefore, very few attorneys can afford to represent prisoners, regardless of how meritorious their claims are. The impact is devastating for prisoners' claims. Most prisoners are barely literate, much less skilled in the complex workings of the law. Prisoners are dependent on the assistance of attorneys to help them vindicate their civil rights, but they are fundamentally discouraged by the PLRA from doing so. Limitations on awards. The PLRA eliminated mental and emotional injuries without an accompanying physical injury from the list of recoverable injuries. 6 In other words, prisoners could suffer extreme mental injury including mental cruelty and torture, yet they are barred from suing their tormentors. Non-prisoner litigants continue to enjoy the right to sue for mental and emotional injuries without the requirement of proving physical injuries. 2. Limitations on types of relief. The PLRA limits the relief granted in a civil action, allowing it to extend no further than necessary to correct the violation of the federal right of a particular plaintiff or plaintiffs, requiring the relief to be as narrowly drawn as possible. Additionally, the court granting relief must give substantial weight to any adverse impact on public safety or the operation of a criminal justice system caused by the relief. 7 The provision therefore forbids an order that will result in the release of a prisoner, unless other remedies have been attempted and rejected, and a 3-judge panel issues the order. The tone of this provision is clear: make it extra difficult for prisoners to get relief, but if they are granted relief, don't make it too much, and grease the path for prison, law enforcement, and legislative personnel to hamstring the ultimate grant of any relief. Termination of relief. Any relief granted by a court in a prison conditions suit, including those granted before the passage of the PLRA, is immediately and automatically terminated 2 years after its grant, unless the court makes a written finding that the relief remains necessary to correct the ongoing violation of a federal right and is the least intrusive and most narrowly drawn relief possible to correct the violation. 8. The prison and jail officials may move for termination of any relief in a prison conditions suit 2 years after it was granted, and may renew the motion annually. The mere filing of the termination motion results in an automatic stay of the relief previously granted by the court from 30 days after the motion is filed until the court rules on the motion. 9. This provision of the PLRA streamlines the ability of prison officials to file motions to dismiss previously litigated suits they have lost on the merits. It also predisposes the federal courts to dismiss suits in which the prisoners prevailed. This is especially onerous in cases previously settled by a consent decree, in which prisoner plaintiffs may have settled for less than the minimum constitutionally required relief to gain additional relief over the minimum in other areas. Under the PLRA, the additional relief is simply discontinued. Exhaustion of administrative remedies. PLRA provides that a prisoner may not bring a lawsuit challenging prison conditions under federal law unless he or she has first exhausted such administrative remedies as are available. 10 This means that the prisoner must file a grievance and then appeal all the way through the prison or jail grievance system before he or she may bring suit. Exhaustion is mandatory even if the prisoner's suit seeks a remedy, such as money damages, that the grievance system will not provide. 11. This provision impedes prisoners' access to the courts in several important respects. First, many prison grievance systems are complex, with several levels of appeal and very short deadlines for filing a grievance or an appeal. A prisoner who fails to meet these deadlines and navigate this procedural maze may find his or her lawsuit barred from court. Second, many prison systems require the prisoner to attempt informal resolution with the staff member whose conduct is at issue before filing a grievance. Thus, for example, a prisoner who was sexually assaulted by a staff member may have to attempt informal resolution with her rapist before she is even allowed to start the grievance process. Finally, the grievance process is completely under the control of prison officials, who can make it as complicated and onerous as they like in an attempt to frustrate litigation. Before 1996, prisoners could be required to exhaust only grievance systems that had been certified by the United States Attorney General or found by the court to be fair and effective. 12 The PLRA abolished this fairness requirement, and now requires prisoners to exhaust whatever grievance system prison officials establish. Prison officials do not hesitate to wield the power given them by PLRA's exhaustion requirement. In 2001, prisoners housed at Wallens Ridge State Prison, a supermax prison in a remote corner of Virginia, filed suit in federal court, alleging a pervasive climate of excessive force. At the time the prisoners successfully exhausted the grievance system, it had 3 steps. 3 weeks after the prisoners filed suit, the warden issued a directive stating that henceforth, the grievance system would have 6 steps. 13. In forma pauperis reforms. Prior to the enactment of the PLRA, a prisoner with little or no money could file a lawsuit without prepayment of filing or other court fees. Post-PLRA, prisoners have no such option. Scrutiny of prisoner trust fund accounts is strict and, even in jurisdictions where prisoners are not paid for their labor, even near-destitute prisoners are required to pay a portion of the fees and the remainder by installments reckoned as a percentage of their trust fund balances. 14 Indigent non-prisoner litigants, of course, continue to enjoy their right to affordable and free access to the federal courts. With the enactment of the PLRA came the three strikes rule, disallowing a prisoner from filing a lawsuit as a pauper if, while he was a prisoner at any time in the past, 3 lawsuits were dismissed as frivolous, malicious, or for failing to state a claim upon which relief may be granted. 15. While this might not seem particularly onerous, keep in mind that most prisoners now act as their own lawyers, and may easily make out what is seen by the courts as a frivolous claim, or fail to state a viable claim for lack of knowledge of the subtleties of the law and the complexities of legal pleadings. A prisoner who is unskilled in the law knows only that a wrong has been committed, and how to describe the facts related to that wrong. Under the PLRA scheme, the pro-se prisoner can easily gain a strike for failing to state a claim upon which relief might be granted even with a legitimate claim. If not initially frustrated by the morass of procedural barriers to litigation, the average indigent prisoner will eventually be trapped by procedural errors to come. Then, as quick as 1, 2, 3 strikes, the prisoner is permanently barred from court. But that is the purpose of the PLRA. The writ of habeas corpus. The writ of habeas corpus has existed in English common law since the 1300s. By the mid-17th century, the writ of habeas corpus was established as the premier mode for attacking illegal confinement, having become codified in England's first Habeas Corpus Act in 1641, and refined in a second Habeas Corpus Act in 1679. By the time the United States Constitution incorporated the writ of habeas corpus, it had existed as a common law right for 4 centuries and enjoyed a 130-year history as statutory law. Immediately upon passage of the Bill of Rights in 1789, Congress enacted a habeas corpus statute providing for habeas corpus review of the constitutionality of all arrests made under the color of federal law. 16 Because the federal constitutional right to habeas corpus did not extend to state actions, state prisoners initially had no federal right to challenge their state convictions. In 1867, the Judiciary Act granted jurisdiction to the federal courts to review all habeas actions, whether pursuant to state or federal law. 17. The statute remained largely unchanged until the enactment of the Anti-Terrorism and Effective Death Penalty Act in 1996. Until EDPA, it was the primary vehicle for state and federal prisoners to challenge unconstitutional actions of police and prosecutors that led to the prisoner's confinement. Hobbling habeas. State and federal prisoners, including those with capital cases awaiting execution, historically have used federal habeas corpus to regain their freedom, or at least another day in court. Eager to shut down a prisoner's last effort at appeal, and undaunted by stakes that may include death, Congress enacted EDPA with little real dissent over its radical provisions. In the wake of the Oklahoma City bombing of 1995, conservatives who had been struggling for years to hobble the writ saw their opportunity and took it. 18. Then, after the Oklahoma City bombing in 1995, conservative forces saw an opportunity to finally force passage of radical reforms to the habeas corpus statute. Cynically packaging the proposed reforms as a necessary tool in the fight against domestic terrorism and banking on the public fury following the bombing of the federal building in Oklahoma City, habeas corpus detractors cobbled together a new bill. Entitled the Anti-Terrorism and Effective Death Penalty Act, the bill dramatically overhauled the availability of habeas corpus review for state prisoners, reforms that had little or nothing to do with combating acts of domestic terrorism, which are generally prosecuted in federal courts. Notwithstanding the lack of a logical connection between the ostensible objectives of the legislation and the proposed reforms, the conservatives had a sure winner. The bill passed by an overwhelming margin. Detractors of habeas corpus claimed that the scattered successes of some prisoners was a gross expansion of the right to habeas corpus, and therefore called for massive diminishment in its scope. The Supreme Court, however, had already erected many barriers to prisoners' relief via habeas corpus prior to enactment of EDPA. Prisoners' successes were so limited that in the 12-month period ending September 30, 1995, a total of 1,062 petitions were filed in federal courts in the Seventh Circuit. Of that number, the district courts disposed of 986 petitions, granting only 14. A grant rate of 1.5% hardly indicates a federal judiciary that routinely second-guesses the results reached in state courts. 19 Nonetheless, the detractors prevailed, and on April 24, 1996, EDPA was enacted, significantly curtailing the rights of federal habeas corpus litigants. Now a win rate of 1.5% in habeas corpus litigation seems astronomical. The impact of EDPA. The EDPA is a multi-pronged attack on American federal habeas corpus rights. It requires that federal courts defer to state court interpretations of fact and federal constitutional laws, substantially increases the burden of proving entitlement to relief, imposes an unprecedented statute of limitations on the filing of a petition for federal habeas corpus review, and curtails the federal court's ability to grant evidentiary hearings. EDPA also severely reduces the availability of habeas corpus review of INS decisions to deport non-citizens, and increases the difficulty of appealing an adverse habeas corpus decision as it imposes new, severe procedures and requirements for filing a successive petition for writ of habeas corpus. EDPA's supporters made their intentions quite clear. The purpose of EDPA was to shift primary responsibility for habeas corpus review to the state courts. Point 20. Consider the following examples of wrongly accused prisoners who would not have received relief from execution under EDPA's requirements. Reuben "Hurricane" Carter, the famous former boxer, was sentenced to death for the murder of a police officer. He was eventually found innocent of the crime and released from prison. Carter was vindicated via federal habeas corpus over 20 years after his imprisonment, when a court determined that prosecutorial misconduct, police misconduct, and extreme local racial prejudice led to the erroneous conviction. If his motion for habeas were brought now, it would likely have been thrown out of court without a ruling on the merits under EDPA's time limitations and state remedies exhaustion provision. Point 21. In another high-profile case in Illinois, 13 death row prisoners were recently released by Illinois Governor George Ryan when DNA evidence conclusively proved they were innocent of the crimes for which they were convicted. Governor Ryan immediately announced a moratorium on executions. In announcing the moratorium, Ryan said, "What is unique about Illinois is there has been better reporting and uncovering of problems that also exist elsewhere, often to a greater extent." The exoneration of the Illinois prisoners was due to a robust process of habeas corpus review. A less searching review will inevitably lead to innocent persons remaining in prison, or being executed, as occurs in more careless jurisdictions. The primary instrument to forestall the execution of innocent citizens, the federal writ of habeas corpus, has been so gutted by EDPA that we can expect more, not fewer, innocent lives to be snuffed out by government. Deference to state court determinations of fact. The EDPA requires the federal courts to defer to state court determinations of fact. Point 22. This represents a codification of existing federal statutory and common law, except that prior law required deference to state factual determinations only if the prisoner had been given a full and fair opportunity to develop and present the factual issues in state court. Point 23. Now the requirement of a full and fair opportunity falls away, and the only check on the state's factual findings is whether they are unreasonable in light of the record. This places the ability of a state prisoner to pursue federal habeas corpus in the hands of the party the prisoner is litigating against the state. Deference to state court determinations of federal law. Under EDPA, the federal courts are also required to defer to the state court's interpretation of federal law, even if it was clearly wrong, so long as it did not directly contravene a Supreme Court decision. Point 24. Thus, the state courts become the primary arbiters of the prisoner's federal habeas corpus rights. Prior to the enactment of EDPA, a prisoner could use the published final opinions of the United States District Court and United States Court of Appeals for the Federal Circuit in which he was convicted or incarcerated as a valid basis for his petition for a writ of habeas corpus. Under the EDPA, only the opinions of the Supreme Court count, and then only if the state court's decision was contrary to or an unreasonable interpretation of the Supreme Court's decision. Point 25. This means that, even if lower federal courts strongly disagree with the state court's interpretation of the Supreme Court's opinion, or if there is no controlling Supreme Court authority, the state court's decision stands, as long as it was not unreasonable. Statute of limitations. Imagine a teenager with nothing but medical textbooks and an 8th grade education to guide him as he rapidly performs brain surgery on himself, and you have an idea of the obstacles facing the typical prisoner who wishes to challenge his capital conviction. EDPA set a statute of limitations on the use of federal habeas corpus, bringing life to the scenario. Point 26. Prior to the enactment of EDPA, there was no statute of limitations on the right to federal habeas corpus. The Supreme Court had only allowed a time limitation on habeas if a prisoner's unjustified delay effectively prejudiced the state's case. Point 27. Now prisoners must file their habeas corpus actions in federal court within 1 year of their state convictions becoming final, or the ability to use habeas is lost forever. Consider the 1-year clock in this light. Because the state is not required to appoint an attorney for a prisoner filing a habeas petition in non-capital cases, prisoners are on their own to secure counsel for their post-conviction appeals. And now many prisoners must act as their own counsel, hamstrung by the complex barriers presented by EDPA that actively discourage and limit the availability of professional legal assistance in this area of litigation. It is more typical that prisoners must craft their own habeas actions, rather than find the rare attorney who will do it for them. Consider, too, that habeas law is one of the most complicated, difficult areas of the law. The implications are clear for prisoners who typically possess less than even a high school education and are unable to afford counsel. Thus, prisoners are at a significant disadvantage for navigation of the tangled web of legal procedure that faces them upon conviction. But the prisoner has only time on his hands and well-stocked law libraries to spend it in, or that's what many people erroneously believe. However, law libraries are currently being dismantled across the country under a Supreme Court case holding that prisons are not required to maintain law libraries. Point 28. Taking the cue, prisons in Utah, South Dakota, North Carolina, Idaho, and Arizona have done away with their law libraries, leaving a vastly indigent prisoner population to their own, very limited devices. Even assuming the best-case scenario where a prisoner is lucky enough to be in a prison with a law library, and finds an experienced prison lawyer to help with the procedural hurdles, there are many more obstacles to overcome. To effectively litigate a habeas corpus action, the prisoner must have a copy of the state trial court's records. Most states charge a small fortune for these trial transcriptions. What ensues is a battle to get the records in some other way to fight the conviction. This battle for transcripts may take up most, or all, of a year's time, a potentially fatal loss of time considering EDPA's 1-year statute of limitations. Then, under EDPA, a prisoner must first exhaust all state remedies before petitioning for federal habeas corpus relief. This means that a prisoner must work his or her way through all available state remedies and courts before bringing a habeas petition in federal court. Most states have some form of post-conviction remedy, and the prisoner must first learn their procedure and pursue them. The time after the state remedy is filed does not count toward the 1-year limitations period, but the time spent obtaining the record, finding the errors in the record, marshaling the facts, researching the law, drafting the pleadings, and learning the state court's procedures does. Once the state courts deny the post-conviction relief, the clock starts ticking again, and the prisoner is faced with another round of fact-gathering, legal research, and drafting of the habeas petition. If, by this time, the 1-year clock still has some time on it, the prisoner may actually file the petition for a writ of habeas corpus in federal court. Because much of how the federal petition will be drafted depends upon what the state court's findings of facts and conclusions of law are, little of the work necessary to produce the federal petition can be performed while the state remedy is pending in state court. Suddenly, 1 year doesn't seem like such a long time after all. Certainly college-educated law school students need more than a year to learn the theoretical aspects of the law. Unrepresented prisoners must then learn and practice one of the most complex areas of law in their own cases in a mere 365 days. Successive petitions and procedural default. Prior to the passage of EDPA, a prisoner could file a successive federal habeas corpus petition only upon the showing of a reasonable explanation of why the error was not addressed in the previous petition, and with proof that the error actually prejudiced the prisoner. This was called the cause and prejudice standard. The cause generally had to be something outside of the prisoner's control, such as a new change in the law or the state's withholding of evidence of innocence. 29. Now, before a successive petition may be filed, the prisoner must first get permission from the appropriate Federal Circuit Court of Appeals. The only reasons for granting permission to file a successive petition are either, 1. The claim rests on a new rule of constitutional law made retroactive to habeas corpus cases by the Supreme Court, or 2. The facts underlying the claim could not have been reasonably discovered by the prisoner prior to the filing of the first petition and are so compelling that no rational jury would have returned a guilty verdict. 30 This change makes it much more difficult to get federal court review of the merits of a successive petition. The claim must not only be based on new retroactive law, or previously undiscoverable facts, but also must be accompanied by a colorable showing of actual innocence. In other words, even if one can present a claim of a substantial constitutional violation that could not have been previously presented, there is no federal review of the claim unless the prisoner can also make a colorable showing of innocence. In short, prisoners who can show only that their convictions were unconstitutionally obtained but not that they are possibly innocent are categorically barred review. Prior to EDPA, a prisoner was required to first exhaust available state remedies by presenting his federal claims to the highest court in the state hearing criminal matters. 31 If the prisoner failed to exhaust state remedies, the same cause and prejudice test applied in determining whether to excuse the failure. Additionally, the failure could be excused if the prisoner showed compelling proof of actual innocence. 32 Now a prisoner must still exhaust state remedies, however, courts' recent interpretations have weakened the cause and prejudice test, and there is not even an exception to procedural default based on actual innocence. Essentially, a prisoner may procedurally default on his or her claim because of a technicality, rendering the claim forever barred from being heard by the courts even if that prisoner is actually innocent. 33. Deportation. The passage of EDPA marked Congress's successful attempt to eliminate habeas corpus relief for aliens under an order of deportation due to a criminal conviction. It eliminated the language in the Immigration and Naturalization Act that any alien held in custody pursuant to an order of deportation may obtain judicial review thereof by habeas corpus proceedings. 34 Replacing it with, notwithstanding any other provisions of law, no court shall have jurisdiction to review any final order of removal against an alien who is removable by reason of having committed a criminal offense. 35. Even though the obvious intention of this language is to deny aliens convicted of criminal offenses their right to habeas corpus review of the legality of their detention, most of the courts that have reviewed the law have interpreted it to allow a limited review for purely statutory questions under the general habeas corpus statutes. 36 If interpreted otherwise, the law might run afoul of the habeas corpus suspension clause, which forbids the peacetime suspension of the right to habeas corpus. 37. EDPA also modified the INA by adding a provision that limits the ability of aliens to apply for a waiver of deportation, where those aliens have been convicted of the statute's interpretation of criminal offenses. 38 Aliens who are deportable because they have been convicted of an INA-specified criminal offense have almost no legal recourse. Conclusion. The EDPA and PLRA strike at the heart of federal civil rights vehicles like 1983 and federal habeas corpus, imposing on prisoner litigants arduous restrictions, many of which are the antithesis of the law's historical precedents. Both were passed into law with minimal debate, steamrollered into law as addendums to a large federal budget bill. Some might believe that it is good to hound prisoners out of the courts, but this belief is a grave and costly error. One of the central complaints of the rioting Attica prisoners was a lack of an impartial court forum to hear their grievances regarding inhumane treatment and illegal irregularities in their convictions. The courts first began paying attention to prisoners' complaints after Attica's large body count, after which prisoners' demands for humane treatment made the issue one of national shame. One need look no further than the recent events of Cuban prisoners taking hostages in Louisiana to see that EDPA is having an unintended, though totally foreseeable effect. When prisoners are allowed no legal recourse to have their grievances addressed, they are forced to resort to whatever means available. It is in society's interest to allow prisoners their day in court, rather than to so limit the rights of all prisoners in reaction to the perceived abuses of a few. Notes: 42 U.S.C. 1997e. 42 U.S.C. 1997e. 42 U.S.C. 1997e. Boyven v. Black, 225 F.3d 36. 42 U.S.C. 1997e. 42 U.S.C. 1997e, 28 U.S.C. 1346. 18 U.S.C. 3626. 18 U.S.C. 3626. 18 U.S.C. 3626. 42 U.S.C. 1997e. Booth v. Cherner, 532 U.S. 731. 42 U.S.C. 1997e. Wallens Ridge State Prison, Warden's Directive No. 4, February 28, 2001. 28 U.S.C. 1915. 28 U.S.C. 1915. Judiciary Act of 1789, Chapter 20, 14 Stat. 1 Stat 81-82. Judiciary Act of 1867, Chapter 28, 14 Stat. 385, Cr. Stephen Painter, Jr., O'Sullivan v. Boerkel and the Default of State Prisoners Federal Claims, Comedy or Tragedy. 78 North Carolina Law Review 1604. For 13 years, conservative forces had attempted to revise habeas corpus laws to eliminate prisoners' abuse of the writ. In 1988, Rehnquist, acting in his capacity as CEO of the Judicial Conference of the United States, appointed an ad hoc committee that was chaired by retired Supreme Court Justice Lewis Powell, to examine the post-conviction process in capital cases. The conservatives deferred action until the Powell Committee could present its report. The reports of the Powell Committee and an ABBA task force on death penalty habeas corpus were released in 1989 and habeas corpus reform bills immediately followed. Each year from 1989 until 1994, bills proposing draconian restrictions on the availability of federal habeas corpus review were introduced into Congress. Each year, however, they were defeated. Moliterno v. Nelson, 114 F.3d 629, 630. The estimation noted pertains solely to the Seventh Circuit. The reversal rate in other circuits was higher than 1.5% and lower in others. 28 U.S.C. 2254, 28 U.S.C. 2254, Lind v. Murphy, 521 U.S. 320, 28 U.S.C. 2244, 28 U.S.C. 2254, Keeney v. Tamayo-Reyes, 504 U.S. 1, 11, 8 U.S.C. 1105a, 28 U.S.C. 2253, Frapp 22, 28 U.S.C. 2244, Thompson v. Calderon, 523 U.S. 538, Hahn v. United States, 524 U.S. 236, 254. Under EDPA, 28 U.S.C. 2244, the statute of limitations would have begun to run from the date that Carter's conviction was affirmed on direct appeal, i.e., 20 years before habeas relief was finally granted, with relief precluded by the sole. He may have alternatively invoked 28 U.SC. 2244, which provides that the sole begins to run from the date on which the factual predicate of the claim or claims presented could have been discovered through the exercise of due diligence. This provision allows that if the factual basis for Carter's challenge could not have been discovered through due diligence until many years after his conviction, the sole would not preclude federal review unless he waited more than a year from the date that he discovered the factual basis to file his federal petition. Whether this provision is applicable depends upon when the factual basis for Carter's challenge was discovered, whether it could have previously been discovered through the exercise of due diligence, and how much time lapsed between the discovery of the factual basis and the filing of the petition in federal court. Though this provision possibly could have been invoked, it is unknown whether it would have applied, and demonstrates yet another obstacle to relief no matter the circumstances under EDPA. 28 U.S.C. 2254. 28 U.S.C. 2254. 28 U.S.C. 2254. 28 U.S.C. 2254. 28 U.S.C. 2244. Rule 9, Rules governing Section 2254 cases, Launcher v. Thomas, 517 U.S. 314. 28 Lewis v. Casey, 518 U.S. 343. McCleskey v. Zant, 499 U.S. 467, 493-94. 28 U.S.C. 2244, Thompson v. Calderon, 523 U.S. 538. Ex parte Royale, 117 U.S. 241, Ex parte Fonda, 117 U.S. 516, 28 U.S.C. 2254 and McCleskey v. Zant, 499 U.S. 467, 493-94. 28 U.S.C. 2254. 8 U.S.C. 1105. INA 242, 8 U.S.C. 1252. 28 U.S.C. 2241, Goncalves v. Reno, 144 F.3d 110, 125-26, Tucson v. Inns, 123 F.3d 487, 489-90, Manser v. Inns, 123 F.3d 423, 426, Augusta v. Attorney General, 118 F.3d 723, 726 N7, Romalo v. Reno, 114 F.3d 1210, 1214 and N1, Fernandez v. Inns, 113 F.3d 1151, 1154-55, Williams v. Inns, 114 F.3d 82, 83-84, Salazar Haro v. Inns, 95 F.3d 309-311, Hincapié Nieto v. Inns, 92 F.3d 27, 30-31, Duldialau v. Inns, 90 F.3d 396, 404. The privilege of the writ of habeas corpus shall not be suspended, unless when in cases of rebellion or invasion the public safety may require it. Article I, Section Clause 9, 2, or the United States Constitution. INA 212. This article was published in 2001. The Limits of Law. Mumia Abu Jamal. doi, 10.4324/97802039526227-42. Human law is law only by virtue of its accordance with right reason, and by this means it is clear that it flows from eternal law. In so far as it deviates from right reason it is called an unjust law, and in such a case, it is no law at all, but rather an assertion of violence. St. Thomas Aquinas, Summa Theologia. It is tempting for many to regard the law as a thing that is almost sacred, as an expression of the highest secular thought. Courts of law bear a striking resemblance to churches of religion. Both are often situated in large, imposing, intimidating buildings. Both feature large center aisles to accommodate large masses of people. Both have raised places in the front, an altar in church, a bench in court. Both priests and judges wear large, flowing black robes. Where one places a deity at the altar, the other places a being upon an elevated bench, who is said to possess godlike powers over life, liberty, and property. A church administrator is called Reverend or Your Eminence, a judge is addressed as Your Honor. Yet while one may opt for faith in a church, faith is surely misplaced in a court. For the law is not a religion, but a set of ideas designed to protect the dominance and the maintenance of those who rule. Under all the robes, the architecture, the books, and other such artifacts, lie the interests of those in power. As such, the law is inherently conservative, as shown by the extreme rarity of the grant of temporary restraining orders or preliminary injunctions, thereby preserving, in most instances, the status quo. What's wrong with preserving the status quo? If the status quo is an oppressive one, with white supremacy as the guiding principle, to preserve such a regime is wrong indeed. If the status quo is on the side of wealth and class, with the poor in a position where their interests are trampled on, then such a system cannot be called a fair one. Black law professor Derek Bell explains the law functions under what he calls interest convergence, which means the interest of blacks in achieving racial equality will be accommodated only when it converges with the interest of whites. However, the 14th Amendment, standing alone, will not authorize a judicial remedy providing effective racial equality for blacks where the remedy sought threatens the superior societal status of middle and upper-class whites. If this is so in law as generally practiced, what of prisoners' law, brought to bear by legions of jailhouse lawyers in every state of the Union? Many jailhouse lawyers know, only too well, of good, solid suits tossed out of court on the whim of a conservative judge, preening for his next judicial appointment. They know, from their own experience, that they are damned at the doorway of the courthouse, and it will be the rarest piece of luck if they can prevail in court. Seen from Bell's perspective, the law protects white class interests, above all else. That's what they are in business for. Weiss über alles is the ruling, unwritten law. Sources: Derek Bell, Critical Race Theory, The Key Writings That Formed the Movement, eds. Kimberly Crenshaw, Neil Gotanda, Gary Peller, and Kendall Thomas. This article was written in 1998. Contributors: Mumia Abu Jamal is a journalist and activist on death row in Pennsylvania. He has authored Live from Death Row and Death Blossoms, and he is also a prison legal news columnist. Nell Bernstein is a media fellow with the Center on Crime, Communities, and Culture of the Open Society Institute in New York. Her fellowship work focuses on the impact of parental incarceration on children and families, and has appeared in Salon.com, Redbook, and The Industry Standard. She garnered the Pass Award from the National Center on Crime and Delinquency for her fellowship work. Her writing on child welfare and criminal justice has appeared in numerous national publications, including Glamour, Health, Mother Jones, Newsday, O, The Oprah Magazine, and The Washington Post. Stephen B. Bright is the director of the Southern Center for Human Rights in Atlanta, and teaches courses on criminal law and capital punishment at the Harvard and Yale law schools. As director of the center since 1982, he has defended people facing the death penalty and represented people suffering human rights abuses in prisons and jails in the South. He was a public defender from 1976 to 1979, a legal services lawyer from 1975 to 1976, and directed a legal clinic for 5 law schools in Washington, D.C., from 1979 to 1982. His work and that of the center have been featured in 2 books, Proximity to Death by William McFeely and Finding Life on Death Row by Kate Alezin. Daniel Burton Rose is a freelance journalist whose writing has appeared in Z Magazine, Vibe, San Francisco Bay Guardian, Middle Eastern Report, Dollars and Cents, and The Multinational Reporter. He is a co-editor of Battle of Seattle, The New Challenge to Capitalist Globalization, and The Selling of America with Paul Wright and Dan Pence. He also assisted with research for Ken Silverstein's Private Warrior. Noam Chomsky is a world-renowned political activist, writer, and professor of linguistics at Massachusetts Institute of Technology, where he has taught since 1955. He has authored over 35 books on political philosophy and linguistics. Matthew T. Clark earned an MS in chemistry from the Johann Wolfgang Goethe University in Frankfurt, Germany, and an MA in the humanities from the University of Houston Clear Lake, the latter earned while serving time in the Texas prison system. His publications include articles in scientific journals, legal and news articles in Prison Legal News and other legal journals, and short stories. He is currently serving a 174-year sentence in Texas. Anne-Marie Cusick is the managing editor of The Progressive. In 1996 her investigative report on the Stun Belt won the George Polk Award for magazine reporting. Her investigative reporting has also won 2 Project Censored Awards, in 1997 and 1998. Cusick also writes about politics and culture, and is a poet. Her first book of poems was published in 2001. Mark Dow is a Brooklyn-based writer. His work on immigration detention has won a Project Censored Award, and has appeared in PLN, Index on Censorship, The Texas Observer, and the Miami Herald. He is co-editor, with David R. Dow, of Machinery of Death, The Reality of America's Death Penalty Regime, and is currently working on a book about the Immigration and Naturalization Service. Joe L. Fraser is the author of The Territory of Men, a memoir, published by Random House in summer, 2002. A McDowell Fellow, Fraser has an MFA from the University of Iowa. She has received several fellowships and awards and has been nominated for a Pushcart Prize. Her essays, stories, and interviews have appeared or are forthcoming in the Iowa Review, Michigan Quarterly Review, Fourth Genre, Nerve.com, Tin House, and Zaziva. She teaches writing, serves on the review panel for Caldera Artists Colony, and writes book reviews for the San Francisco Chronicle. Alex Friedman is a former Tennessee state prisoner. A frequent PLN contributor, Alex focuses his activism on the private prison industry. Judith Green is a criminal justice policy analyst and a SARA Senior Justice Fellow. She is a consultant to Families Against Mandatory Minimums, the Justice Policy Institute, the RAND Corporation, and Human Rights Watch. Over the past decade she served as a senior research fellow at the University of Minnesota Law School, and directed the state-centered program for the Edna McConnell Clark Foundation. From 1985 to 1993 she served as the director of court programs at the Vera Institute of Justice. Ms. Green's articles on criminal sentencing issues, police practices, and correctional policy have appeared in numerous publications, including The American Prospect, The Index on Censorship, Crime and Delinquency, Current Issues in Criminal Justice, Prison Legal News, Overcrowded Times, The Wake Forest Law Review, The Rutgers Law Journal, The Justice Systems Journal, and Judicature. Gordon Lafer is an assistant professor at the University of Oregon's Labor Education and Research Center, and is the author of the Job Training Charade. He has worked as a union organizer for hotel workers, construction workers, and university teachers, and is a member of the National Steering Committee of Scholars, Artists, and Writers for Social Justice. His articles have been published by the American Prospect, Dissent, New Politics, and Politics and Society, among others. Adrian Lomax is a Wisconsin prisoner, jailhouse lawyer, activist, and writer. John Midgley is a prisoners' rights attorney who has represented Washington state prisoners both individually and in class actions for the past 25 years. He has worked with the Institutions Project at Columbia Legal Services in Seattle, where he is currently the regional coordinator. He writes a quarterly column for PLN entitled Pro Se Tips and Tactics. Robert Owen is a former federal public defender now in private practice in Austin, Texas, with a practice focused on death penalty defense. Christian Parenti is the author of Lockdown America. His writing has appeared in The Nation, The Progressive, In These Times, and the Christian Science Monitor. Bob Posey is a Florida prisoner and activist. He is also the founder and editor of Florida Prison Perspectives, a bi-monthly prisoners' rights magazine. Kevin Pranes is the campaign organizer for Not With Our Money, a grassroots campaign to end U.S. universities' financial alliances with private prison industries. He is also a Soros Justice Fellow and organizer with Grassroots Leadership, and a board member of the Prison Moratorium Project in New York. Ken Silverstein is a contributing writer to Harper's and Mother Jones. He also writes for publications such as The Nation, American Prospect, Salon, and Slate. Several of his articles have been nominated for National Magazine Awards. Silverstein is the author of 4 books, most recently Private Warriors, a look at the privatization of national security during the past decade. He is currently at work on a book about the post-Cold War arms trade. Jeffrey St. Clair is an investigative journalist based in Oregon and the co-editor of Counterpunch, a bi-monthly investigative newsletter. Paul Street is the director of research at the Chicago Urban League. His articles, essays, and reviews have appeared in These Times, Z Magazine, Monthly Review, the Journal of Social History, and the Journal of American Ethnic History. Silja J. Talvi is a full-time freelance journalist who focuses on issues pertaining to prisons, women's issues, and criminal justice. Silja writes frequently for publications ranging from the Christian Science Monitor to In These Times. She is also a co-editor of Lip magazine and a frequent contributor to Prison Legal News. Kelly Varela is a graduate student in journalism at UC Berkeley. She wrote her piece while working at Alternet, the news service of the alternative press. George Winslow is an editor and business journalist who has specialized in international business, the global entertainment industry, the drug trade, money laundering, financial fraud, and global crime groups. He has been covering corporate crime for the last 16 years and is the author of Capital Crimes. His work has appeared in the Columbia Encyclopedia, the Encyclopedia of New York City History, In These Times, the New York Times Book Review, and many business publications. He currently oversees all the editorial operations at Reed International Television Group, which publishes such magazines as Television International. He can be reached at gpwin@aol.com. Willie Wisely is an activist and journalist, a California prisoner, and frequent PLN contributor. Ronald Young is a former Texas prisoner, an anarchist, and an activist. He is also the founder of Chain Reaction magazine, and a frequent PLN contributor. Editors: Tara Herivel is a prisoners' rights activist and attorney who has written for Prison Legal News and other progressive periodicals in the Seattle area. Paul Wright is a Washington state prisoner, jailhouse lawyer, political activist, and journalist. Paul is the co-founder of Prison Legal News, a monthly magazine published since 1990, that is prisoner written and edited. He also co-edited The Selling of America with Daniel Burton Rose and Dan Pence. About Prison Legal News. Prison Legal News is an independent, monthly magazine edited by Prison Nation co-editor Paul Wright. Published since 1990, PLN is the longest-running independent, prisoner-produced magazine in U.S. history. With a national circulation of more than 4,000 subscribers, PLN focuses on reporting news and legal developments involving prisons, jails, and the criminal justice system. Each issue is packed with news, analysis, book reviews, and legal information. PLN's content is uncensored. PLN is a 501 nonprofit and is almost entirely reader-supported. If you believe in the concept of an independent media that reports on prison and jail issues from a perspective other than that of the government, the private prison industry, or the lock 'em up crowd, subscribe to PLN today. If you would like to support PLN's work, you may do so by sending a tax-deductible donation to the address below. Those who subscribe at the $60 level or make donations allow us to subsidize subscriptions for prisoners in lockdown control units and on death row. A PLN subscription for 12 issues is $25 and $60 for high-income, institutional, and professional subscribers. A sample copy can be viewed at PLN's website or obtained for $1 from Prison Legal News, 2400 Northwest 80th Street PMB 148, Seattle, Washington 98117, 781 to 6524, PLN at prisonlegalnews.org, www.prisonlegalnews.org.